Let it be placed, my lord. Otherwise,
monthly list है कोई
5th June, my lord. This
date for today, my lord, in the monthly list. I had mentioned before the previous learned judge.
My lord, may I be permitted to mention a depot without certified copy? Certified copy. My lord, with a server copy. I'm filing with a server copy. My lord, it's a DRT application from DRT.
My lord, for upgradation, my lord. Your lordship, can I mention one matter? Your lordship, may I mention one matter if you allow?
Item number 1, my lord, I'm for the petition, my lord. Let me allow to correction, my lord. The correction is, my lord, you will also find that the cost. My lord, the cost title of the revision application. Yes, my lord, it will be instead of my lord, as Amarnath Bosumoldik and others versus Hori Charan Rai. Hori Charan Rai. There were two matters. I am grateful to your lordship. Cheers.
Lord, I am for the petitioner. Lord, this is for extension of interim order, my lord. Lord, the order. Lord, the order, my lord, passed by. Lord, I have served, my lord, the respondent appeared, my lord. Opposite party, my lord. My lord, the opposite 2. But the opposite party number 1, my lord, also appeared on the last occasion. My lord, it is, my lord, basically, my lord, the transaction between two private persons, my lord, will come under the purview of the Consumer Protection Act 2019. My lord. It is, my lord, the sale of a flat, my lord, between two persons. My lord, I am the, my lord, the seller, my lord, and my lord, the opposite party number 1 is the, my lord, the purchase, and the opposite party number 2. No, my lord, I am led by Mr. Mukherjee.
Yes. Lord, by virtue of the order impugned, my lord, the police. Your lordship need not. The main matter is yes, my lord, the warrant of arrest is being issued. Lord, in my respectful submission, Lord, yes. Lord, I have shown before your lordship Lord, I am not on that also. Lord, here it's a repurchase of a flat. It's not that, Lord, a promoter for commercial gain, Lord, he has developed the property and he has, Lord, sold out a flat, where, Lord, the deficiency of service lies. But here, yes, it's a, Lord, resale from a person who was the owner of the flat. He has transferred his flat to a third party. So here the question of, Lord, service provider is not there. So, Lord, entire thing, Lord, no, my lord, what happened, my lord? Here, the opposite party number 1 is the complainant. Complaint case, my lord, was being lodged, and thereafter that was being allowed on 22nd May 2013. Appeal was being preferred with a delay of 130 days by my client. The Section 5 application got dismissed on merit. So, my lord, my appeal goes. Thereafter, the execution case is being moved, and in connection with that execution case, my lord, now this order is being passed. But here, my lord, I want to take, my lord, that entire proceeding is, my lord, not maintainable before the court. Lord, your lordship knows if a forum do not have jurisdiction, if it is inherent lack of jurisdiction, then, my lord, it's settled, my lord, by the appellate court. Yes. No, my lord, in my respectful submission, kindly remembers, if a forum do not have jurisdiction, if it is otherwise inherent lack of jurisdiction, then in an execution proceeding or even in a collateral proceeding, I can say that no, this entire proceeding is not maintainable. Your lordship sitting under Article 227 can vary. No. Yes.
Page 54 হচ্ছে appeal before state.
যাই হোক, সেটাই।
I do not
Yes, yes.
Mr. Devanik Banerjee appeared in this matter, but he has retired from the brief, Your Lordship. Now, Your Lordship, I do not have any instructions regarding that. OP number 1.
But there are only two, my lord, opposite party. Mr. Banerjee appeared for opposite party number 1, that is the complainant, and my learned friend is appearing, my lord, for the opposite party number 2, life insurance, who do not have any, my lord, order. My lord, order impugned, my lord, both order dated 20th September 2016 and, my lord, 16th December 2019. Very well, my lord. Very well. I shall do that. Lord, kindly, my lord, protect me for some time. I shall file an application, and execution, my lord, is December 16, 2019 is, my lord, the order challenging 20th September, that your lordship will find, my lord, at page 52. Section 47, my lord, no, it is do enjoy some of the power. No, kindly takes up, my lord, once page 52. Just a minute. Yes, that is, my lord, the issuing of warrant of arrest. (2013), my lord, that is the initial order. Arrest warrant order page ta bolo. Kindly it comes to once page 52. 20th Sep. Yes, yes. That's why, not page 52. Order number 27. Order number 27, dated 20th September 2016. Now, my lord, immediately thereafter in 2017 itself, this appeal is being preferred. This is not page 54. application under section 17(1)(b), so old act. Revision. Yes, that is not the order impugned. Yes. Yes. And in my revision, I have specifically taken that point. Page 56, point number III. That is regarding that if it is warrant of arrest, then this honorable court to have jurisdiction to entertain under Article 227. That at the time of even admission, I have shown to your lordship this Supreme Court decision, by virtue of which your lordship subsequently delivered a judgment, detailed judgment. Yes, yes, yes. Today, I have not, because I have brought this act itself where the service provider is being defined and this exception is being carved out. Before the executing court itself, I can prefer an application stating that this is not maintainable. This can be done since it is an inherent lack of jurisdiction. That's why your lordship can give me a liberty so that I can take this point and the executing can decide that on merits. Because it's a settled law. If it is inherent lack of jurisdiction, they cannot.
My lord, I used to appear, then the client has taken a no objection from me. And Mr. Deeptomay Talukdar was appearing with Mr. Pratip Mukherjee thereafter.
Oh,
But I think I have Mr. Talukdar now. I'll just.
He cannot say that if it is inherent lack of jurisdiction, he cannot say I cannot go beyond the degree. It's a question that whether the decree is otherwise. Yes, this is that I have shown. The Supreme Court, your lordship has relied that. Yes. Tomorrow is the date fixed, right? In the execution. That is your lordship protect me for some time. I can also, I have the Mr. Talukdar. Yes, I have Mr. Talukdar's number also. Very well. Correct. I beg to appear on behalf of the petitioner.
My lord, I am for the opposite party number 1 to 4, my lord, led by Mr. Soumik Ganguly.
Here, the amendment application preferred by a pro forma defendant in a suit for partition is being turned down, though the trial of the suit has not yet been commenced. No, they said by virtue of a lease deed, whatever right is being created in my favor, that is not tenable in the eye of law. That is one of the declaration that has been shot for in the plain. Then the first prayer kindly looks at. Yes, page 9, the plain starts. The prayers is at page 15. 1-5, 1-5. First prayer, small a. Yes, kindly looks at my amendment. That is, amendment application starts with page 28. The schedule of amendment is at page 31. There are certain transfer being made by the predecessor of the plaintiff. I stated that after coming to know, I stated that after those transfer being made by the original predecessor, the share that has been claimed by the plaintiff, that cannot be there. That will be reduced. And the other, on the other hand, they have not denied the factum of those execute. Yes, my lord, schedule of amendment at page 30. Yes, my lord, page 31, my lord, kindly take 31, the amendment starts. Andobala Dashi is the predecessor. She during lifetime has executed the deeds. So, lord, the plaintiffs being the heirs of Khandobala cannot claim the share which was transferred during the lifetime of Khandobala. Yes. From Khandobala, after death, partition. Lord, in my respectful submission, it's not a question of, Lord, whether I am being affected or not. I have been added as one of the, yes. Because ultimately it's a suit for partition. The court has to quantify the share at the time of passing the preliminary decree. So this factor, yes, Khandobala, outsiders, yes, that's why I have brought everything brought to the notice of the court, so that ultimately the preliminary decree, the court has to decide the share of the parties. Yes, shoes. Exactly. That's why the court cannot say, you being a party, you being a pro forma, you cannot. Yes. Definitely. And in the written objection, they have not denied regarding the execution of those sales. They stated that all along you have not knowledge.
My lord, Mr. Ganguly is appearing, my lord. No, my lord, I'm not mentioning. Without,
Extension.
my lord, kindly take up at 2 p.m. My lord. Yes, ma'am.
Yes, yes, I'm such. Knowledge can be taken at any. Yes, yes, yes.
But I am for the petition for extension of interim order. Initially, affidavit service has been filed. On the last occasion, when the matter was listed before Justice Patnaik, I have sent a letter to the learned advocate for the opposite parties appearing before the trial court by WhatsApp. And it is the I have affirmed the affidavit of service to that effect. The letter and the initially it has been served, but since it was my time was short, in that event the extension of interim order, my 20th is the next day. By the order, my improved order, the learned judge has directed me to pay a court fees. According to him, it is a deficit court fees, but my lord, he has taken into consideration the Court Fees Act of Punjab. not the Haryana, Punjab, Haryana's court fees have been taken into consideration. The Supreme Court judgment mentioned in the implement order. The Supreme Court has taken a decision that in this case, it is relates to Punjab and Haryana case. The petitioner has to pay, plaintiff has to pay the court fees deficit. Our West Bengal Court Fees Act does not have that provision. Therefore, we shall not be guided by the Punjab Haryana court. For payment of court fees relating to filing of the suit. Yes, that I have paid. But according to the learned judge, suit for Mala declaration and injunction, declaration of right title interest and injunction. I have paid for declaration of right title interest as well as declaration that registered deed is inactive, invalid. But according to the Punjab Haryana Act, he has to, my lord, pay for cancellation of deed and court fees is different. In our court, my lord, the court fees is, it is already, there are decisions, my lord, of I'm good.
Very pleased, your lordship. I am for the petition. Pursuant to the order of the Honorable Court, I've served the affidavit.
I am for the opposite party number 2.
From the opposite parties. I respect to Commission vote that on 7th November 2022, the Lordship the Honorable Justice Shwasi Dalgut was pleased to pass. My lord, till the disposal of the application, my learned friend is also. Till the disposal of application, as because 3 times interim order was passed, defendant was directed to file the opposition. In spite of till that they did not.
I will
That
file the
matter is
application.
paying the lordship till the disposal of application, madam. September 1. I'm great.
Deeply obliged.
I beg to appear on behalf of the petitioner, my lord. It's a case under section 22 of the Hindu Succession Act. My lord, the preferential right. The court did not give me protection, my lord, regarding it. This is not a matter, my lord, where the injunction has to be, or the section 22 has to be invoked.
One and another, there are so many men. Okay. Only for 2, my lord. That's why I'm playing people, lords. Lords. All others I have served, my lord.
All right. You have to integrate all of them.
I'm grateful.
My lord, here, my lord, section 22 has to be applied prior to execution of any transfer. My lord, earlier services being made, my lord, interim order was there, my lord, extended from time to time. The section 22 of the Hindu Succession Act, my lord, the preferential right has to be exercised prior to the sale being effected or transfer being effected. Here, the court has, my lord, I have asked for protection. The court said no, the person who has got the interest by way of by 2 ways. One of ways is, my lord, by way of succession, my lord, inheritance. and another is by way of gift deed. Maybe, my lord, that doesn't not change the character or not the entire scenario of section 22, eventualities of section 22. Section 22 said if one of the heir or one of the admitted owner, co-sharer wants to transfer it, apart from the class 1 heirs, then the class 1 heirs do have a preferential right to ask for preemption. So that is there. Whether the person who has got interest not by virtue of any gift deed or through inheritance, that doesn't not change the partex of the character of the section 22. Only on the basis of that, the injunction is being denied. And since it's under section 22 of the Hindu Succession Act, so the regular order 39 rule 1 and 2 will not be applicable. That's why direct revision before this honorable court. It's an application under section 22, not a regular suit. That's why it has been registered also as J. Yes, I'm the. Kindly takes up the page 2 of the order. The last paragraph will clinch the issue. Yes, I'm enjoying that. Suit under section 22 of the. Opposite part. Great.
Well, this was passed in October 2021, taking into account all the previous subject to correction, Lordship, I shall look into. I shall look into. I will.
There was a subsisting interim order, my lord, which has expired. Praying for extension, my lord.
My lord, may kindly take up this matter and.
Yes, my lord. This is, my lord, the application under Order 39, Rule 7, filed by learned friend's client, my lord, that has been allowed. That has been allowed. That
Suit is under section 8 of the West Bengal Land Reforms Act, preemption. My learned friend's client had filed the suit. I am opposing that, Lordship.
39(7) is kindly comes to page 17. Yes, my lord. Schedule is at page 18.
My lord, I wanted to carry out repair at the premises. I run a tin shed shop. My lord, kindly takes up paragraph 7 onwards, Lordship. That is my case. Page 18. My lord, there is no
application for repair, my lord. This is the
because
my lord, application for local inspection. Now, my lord, kindly see what is the, my lord, this is, my lord, preemption. Now, my lord, kindly see to the schedule to note the dilapidated condition of shop room situated on the scheduled suit property and their condition and details. To note the condition of a broken boundary wall surrounding in the suit property and their conditions and details. My lord, these are there. Now, my lord, kindly comes to the impugned order. Order number 34 dated 9/11/2022.
Completely wrong order. Completely incorrect order. Kindly see point number 1. To note whether any shop room is there in the shoot property from the pleadings of this is a Millard. No, first, whether he wants to, Millard, first of all, there is no shop room. Otherwise, it would have been, Millard, appeared from the pleadings itself. First, my learned senior friend has to show that there is existence of a shop room. He cannot, Millard, round in the round way in an application under Order 39 Rule 7. No, Millard, if yes, Millard, if there is, Millard, if there is no existence of a shop room, Millard, there is no, Millard, the repairing need of repairing at all. I could have said at all from pleadings of either of the parties. There is no existence of the shop room. It has to come first. It has to come from the pleadings that there is an existence of a shop room. Millard, an application for local inspection cannot be filed. Millard,
Lordship will kindly take up paragraph 16. I shall just place it. Lordship, with reference to the statements made in paragraph number 2 of the said application, the opposite party states that she is never a stranger to the suit plot of land. And since the day of purchase, she is in peaceful possession of the suit property, which is totally surrounded by boundary walls in all the sides. And the stories of the petitioner as to causing waste and damage by digging earth from the suit property forcibly is false as stated in paragraph 2 and are totally denied and concocted and motivated stories as have been set out by the petitioners are fully denied by the opposite party in toto. The opposite party states that since the day of purchase, the opposite party is in absolute possession of the suit property by construction of structures thereon. And since day of purchase, this opposite party has been paying all panchayat taxes, land revenues, etc. from time to time before the appropriate authority. Now, this is a specific averment I have made in my written objection to the application under section 8, which was filed by my learned friend's client in the court below. So, Lordship, if it is a question as to whether the shop room is there, Lordship, I have stated categorically that there are structures which I have been constructed at my behest upon the property, and I have been, and Lordship, it is an admitted position that I am there in possession of the suit property. And Lordship, prior to my
no, Millard, to note whether any shop room is there.
Lordship, I am grateful.
But Lordship would kindly record I am denying any existence of the shop room. That is my.
I am grateful. My Lord,
18,
page 18 at the bottom.
For the question of repair. Local inspection by a commissioner, advocate commissioner, rather than advocate commissioner, suffice the purpose. suffice the purpose and hence take it as follows. I think we should have around the time five. All the software, the question of submission inspection. The condition of the software, provisions of law and also beyond the scope. The criteria for the submission that statement such fee was never taken by the opposite party. Reduce the from the ground of voting. Fact of the opposite party is the and he said in the place that you want to publish.
Page 12, para 10. Page 12, para 10. Yes, Miller. He forceful possession, but
Came to take.
not to, came to take.
On the contrary, statement
Paragraph 10 तक your due course.
that the opposite party was in possession of the property and had built certain structures. Order to the property and dilapidate structure and the boundary wall. The commission was said that the commission allowed
নতুন বাড়ি পাবো জিতলে শান পার্টি শার্ট টিম সামনে হবে
certain whether
Yes,
any structure on the property required in repaired or not. And such ascertain that by way of an commission, either go down condition of the structure. Under such circumstances, the commission might not have the commission be allowed as per the of the law.
No, the inspection commission has been appointed, not advocate commissioner. 26(9). Local, no, inspection commission,
Yes, yes. Bayan,
not at all.
On the following point below, A, on the following points, A, whether the existing structure fire or damaged damage affected the movement of the structure. That the boundary wall around the damage fire.
চেঞ্জ করছে কেন?
I'm ready for literature. Paragraph 16. What?
I'm grateful, Lordship. দিয়ে দে কৃষ্ণটা নাও।
But I am appearing for the petitioner, my lord, in this matter. Only petitioner is the tenant in the suit for eviction, my lord. There was a 7-2 application earlier filed saying that, my lord, my landlord is the Murshidabad Jila Parishad and I have been paying rent to the Murshidabad Jila Parishad. 7-2 application was initially turned down on the ground of maintainability, that this court cannot decide the question of landlord tenant. Yes, whatever it is, well, that order was set aside by this court and direction was given to dispose of the 7-2 within a specified time. Now, thereafter, my learned court took up the matter, but the difficulty arose. There is a separate proceeding by the Murshidabad Jila Parishad against these landlords relating to the ownership of these self-same properties. Because in a suo motu proceeding before the BL and LRO, my lord, the Murshidabad Jila Parishad was recorded as the owner of the property. No, now that is a separate proceeding. There was initial order of BLRO, learned district judge in an appeal proceeding from that order, set aside that order, stayed that order. Against that, Jila Parishad preferred a revisional application and the order of the district judge was stayed. So, my lord, we prayed and that revision is pending. So, we prayed before, in this suit, we prayed that kindly adjourn this matter because that issue of ownership between the landlord and Jila Parishad is yet to be finally decided, which will have a repercussion on this determination. Yeah, that I'm paying to, that I'm always paying. Well, there is no dispute about it. I am paying to Jila Parishad. Well, since the last 30 years, I'm paying the rent to Jila Parishad. Now, this is the dhors against me and landlord, because I have disclosed the rent receipts and the records which have been produced from the office of the BLRO saying Jila Parishad is the owner. So on that basis, this 7-2 was pending. There is a civil revision pending before this court in respect of a proceeding between Jila Parishad and the dhors, where there is a yes, it is a ground of default. Yes, I am only submitting this, if that revisional application can also be taken up along this and decided together. This is actually the interim order is only to that extent that since there was a stay granted by the coordinate bench in another civil revision application, therefore the learned court below may not proceed with the. And because the learned court below is swayed by an observation of this court that the matter has to be disposed of within 6 months. That is why it is proceeding. It was proceeding. If your lordship kindly sees the earlier order of this court, which is at page 49. Because the court cannot decide this question of title either way until and unless the other revision application. Yes, I am saying Jila Parishad is the owner and they have demanded rent. I have paid rent. And I have also shown the records that shows Jila Parishad has claimed to be the owner on the basis of the BLRO suo motu proceeding. Yes, to the
Lordship, I am led by Mr. Mukherjee, Lordship, Shivashish Mukherjee. My instruction is, Lordship, if my senior friend file an extension of interim, let them the extension order be extended and kindly fix a date for hearing, Lordship.
kindly fix the date of hearing, and if I am only submitting, let that CO also come before it. 3472 of 2019. 3472 of 2019. Any day, my lord. Yes. My lord, one more revision of this same tenant, 374, that was also heard together, same order passed, it has not appeared. That let that appear tomorrow, because the interim order is also there, similar interim order is also there in this matter. Yes, I give the slip. Yes, yes. Yes, on the same. 16th August. Obliged.
Grateful.
নাম্বারটা দিয়ে দাও। Obliged. না, কালকে আরেকটা PO হবে, কারণ যেটা আজকে আসেনি।
Now, my lord, the landlord, my lord, plaintiff is the petitioner before your lordship. My lord, I am challenging an order by which, my lord, the application under 7(2), my lord, of the Premises Tenancy Act has been allowed. My lord, is not maintainable at all. I tell your lordship. Kindly see the rent receipts. 7(1)(c) টা বার করে রাখো। Yes, yes. My lord, otherwise I am on the point of maintainability. 7(2) application. Yes, but kindly see the rent receipts. And the 7(1)(c) and the rent receipts. No, maintainability. Maintainability. Kindly see up to this, my lord, he is depositing every month. Kindly see, he is depositing, kindly see the previous also, he is depositing every month up to this, September or October, my lord. At the right hand side box. For the month. These are the civil deposits, my lord, he is depositing every month. My lord, at the top, my lord, this box, my lord, may I find it up front? The month is there. Yes, he kindly turns over the next page. From November, for 4 years, he pays in the after 4 years. Kindly see, for 4 years. Exactly. Now, my lord, 7(1)(c). Kindly see 7(1)(c) of the West Bengal Premises Tenancy Act. The tenant shall be 7(1). There was no formal application, my lord, that was allowed, my lord, on mere, my lord, on oral application itself, my lord. Application. Now, my lord, 7(1)(c). The tenant shall thereafter continue to pay the landlord or deposit the civil judge month by month by the 15th of itself. But there is an application of 7(1), my lord. That. No, determination 7(1) is only deposit. Only deposit. Determination is on 7(2). Yes. Exactly. And without Miller looking into the maintainability, this aspect court has allowed that. This is my primary point. No, Millard, now Millard, the Vijay Kumar Singh and the Chamaria's judgment says 7-2, Millard, the procedure lays in 7-1 and 7-2 has to be followed, Millard, that is Millard obligatory. Now, Millard, it's 7-1. No, that is after adjudication. This is that is after adjudication. Adjudication. This is, I'm not on that. I say 7-2 is not maintainable in view of 7-1C. Accepted. Accepted, 7-2 allowed. And there it cannot be said that the 7-2 Millard is there is no default. That is also not there. No default cannot be, Millard. No default. Millard, kindly see the defense goals. 1919 SCC. No, that was 19 to 1919 SCC. Now 7-3 is the only consequence. After service, Millard. My suit is being stayed, Millard. My suit is being stayed. পরের দিন বলবে তো শুধু এক্সটেনশন হ্যাঁ দুটো জেরক্স করে আলাদা করে নাও পাঁচটা নাও
Lord, I will appear on behalf of the petitioner.
Inform করেছিলাম after mentioning.
বলে দিন। Lord, you have served.
Served and also inform. And also inform my lord over phone, my lord. After
Lord,
mentioning.
Mr. Shubhrata Shatra is appearing for the opposite parties, but he's engaged in another courtroom, praying for a short passover.
Yes.
Lord, item number 11 also. Next item. No, not same. I'm appearing. Mr. Kushal Chatterjee is appearing for the opposite party. Lord,
Can I take it?
Lord, I have not received the brief, my lord. Lord, there was no caveat from our side.
No caveat is there, my lord, there is no question. If your lordship kindly pass necessary order, my lord, I am giving key. And a copy though. Hearing now, my lord, I am serving the copy. Right? Yes. Shall I go on?
আমি সেলাই করে নেবো
My lord, before my lord pressing the matter, my lord, I tender apology. Like there is a mistake. A wrong documents has been annexed. Wrong order. No, order impugned annexed. But before pressing the impugned order, my lord, kindly hear me the facts of the case. My lord, petitioner. Yes. Yes. Both courts have rejected. Both courts rejected. My lord, kindly hear me, my lord.
what happened? The petitioner is the plaintiff. This is my personal matter, Your Lordship. But suit for title, when an injunction application has been filed. Injunction application has been turned down. And kindly have a look, my lord. That order I have wrongly annexed, my lord. In another, yes, my lord. এই যে, yes, this is the first trial court order, order number 11, first, second, third, fourth, fifth paragraph. I'll kindly have a look. Yes. আচ্ছা, আচ্ছা। Follow up করছো? Shoot for title injunction. Do not, nature of injunction, my lord, do not change the nature and character of the show property. My lord, I respectfully submit to the lordship that this is duly, my lord, the fault of the learned advocate to whom I engaged. What happened, my lord? My place. Yes, plaint, my lord, I have not annexed. Suppose, but I have a copy, my lord. If you love, I have a copy. No, that is appreciate, my lord, but only one thing, my lord. That is my prayer.
Whatever, however you.
But they are trying to change the nature and character forcibly. And my lord, the,
This is the evidence of your either the title or your possession as both are found on facts. When the appellate
this is
court has asked
the
public
in
to
before the appellate court, my lord, I did not take a chance to file my written objection, as well as, my lord, in the an application under order 1 rule 10 for substitute the names of the legal heirs of defendant number 2. That for which, my lord, I came before this honorable court.
right.
Yes, my uncle. Yamin Ali.
My lord, Yamin Ali is defendant number 2.
This is my personal matter. I earlier told, my lord.
My lord, only one thing, my lord, I would say. My lord, I don't know this fact whether substitution was brought on record or not, but court has heard defendant legal heirs of defendant number 2. Now, if that be so, my lord, on that ground, my lord, none of the orders can be disturbed. My lord, in the sense, my lord, kindly turns to their first annexure to this revisional application. I find, my lord, they have filed an application for recalling before the court below. My lord, they are moving parallel proceedings. They are filing recalling in the court below, and they are challenging the revisional order. Now, my lord,
What happened? Kindly allow me to say, my lord.
and secondly, my lord, the order. No,
Lord,
either
I asked for written objection. I have ready by I could not file it due to, my lord, fault of the learned advocate, my lord. This is my, I cannot, my lord, open my mind against an advocate. But what happened, my lord? 9/11/21, the defendant number 2 died. My father. Yamin Ali National, both are brother. Yes.
no, my lord, subject to correction, my well learned senior friend, my lord, kindly takes up the recalling paragraph 10. I was going hurriedly through it. My lord, which
have
they have
annexed, my
filed.
lord.
My lord, kindly turns to, there is no pagination, but annexure G. Pagination called?
Presentation করা আছে, ওটা তো করার নেই। মানে
Pagination
পেজ
বলুন।
পেজ বলছি। Page 32.
So kindly turns to paragraph 10. My lord, there was an application under order 1 rule 10 filed by the legal heirs of the defendant number 2 or the respondent number 2. And what they have done is they have failed to file a written objection to that. My lord, it's not that, my lord, not an application to add the heirs was not there. My lord, the in a suit, yes. Now, my lord, in a suit, my lord knows carriages with them. My lord, if they don't file a substitution application, suit will abate. But the other respondent is not debarred, or defendant is not debarred from making an application for add them as a party. My lord, court has considered and heard the legal heirs of defendant number 2.
Without objection, my lord, because, my lord, I have
But then
I
they'll
have
let the suit be
primary
abated.
objection.
He's objecting to the legal heirs to be added.
I have
And
not
on the
objected.
other
I
hand,
have
he is
not
not filing substitution.
Procedure is illegal.
What
Because, my lord, order 1 rule 10, my lord,
Well, this is pending.
yes, kindly give direction to the learned opponent. Along with, my lord, kindly, my lord, consider my written objection also. And along with my written objection. Kindly mention, my lord. Otherwise, my lord, your
But
lordship
this
knows.
cannot be done. This is in effect, Mueller, virtually touching the order which is found on merit. He has no stand.
But
Yes,
kindly mention that, my lord. Kindly mention. Otherwise, lordship knows, my lord, the
Oh, my lord, a factual correction, my lord, needs to be brought on record by, he has annexed that order by order number 23 dated 29/11/2022. My lord, my application for addition of party was allowed. Yes.
And there is my objection, my lord. Without my lord hearing my objection, my lord, they disposed of the order 1 to 10.
শুটটাই চলে যাবে, তুমি কি করছো?
শুট যাক না আগে এটা করো। Petitioner, one petitioner. লিখেছো, নাম লিখেছো? আমার নাম লিখো না।
My lord, it was their appeal. My lord, it was heard on the what
I have a file objection on an application under
the
order
addition
1.
of party.
Please let me say. Order 1 rule 10 to rule 10.
I thought the addition of party.
हाँ.
Yes.
Because my no, their heirs are necessary parties, but their procedure is wrong. Okay, there is a specific provision for substitution of legal heirs of.
And they want their interest in the property. Are they allowed to go and file?
No. They have filed an application for order 1, because there is a specific provision under order 22 to substitute. Yes, that is true, but and another.
That the heirs of the order passed by the
Great one, great one.
No job.
Great one.
I beg to appear on behalf of the petitioner. Defendant number 1 and 2, my lord,
Before taking
Res-
to the matter, I'm
respondent-
thing that learned advocate Aditi Kumar is appearing on behalf of the opposite party number 1 and 2. Actually, my lord, her mother is suffering from 4th stage of brain cancer. Kindly, my lord, I am seeking for 2 weeks adjournment.
2 weeks, my lord.
At least, my lord, 10 days.
My lord, the order,
7 January.
my lord, two of the member of a union whose membership, one of them membership is being cancelled in 2014. No, my lord, it's injunction, my lord, it's a, my lord, two of the member who has been expelled from their membership, one in 2014 and another union, my lord, in 2022. My lord, series of suit, series of order that these two members cannot act as a member of the union. Then also times and again, my lord, they published a list saying that yes, this is the general body. Now we have framed in meeting, putting these two members to be one of the office bearers in the list. They want to publish this to the railways. Even in 2022, we filed a suit, obtained order of injunction against these two persons. Now, subsequently, this suit is being filed again, saying that in 2023 they have prepared one list, and now the trial court has not refused the order of injunction, saying all these things of the previous suits, and his membership is being
And
cancelled.
then what happened?
In miscellaneous appellate court, they have restrained us from interfering with the business of that union through that committee that has been framed.
The appeal is
Ignoring
pending.
they have alleged to have held any meeting, and they
Is
have
the appeal pending,
no miscellaneous appeal
disposed of?
disposed of till disposal of the suit.
Actually, my lord, my
That's why
instruction,
the entire union functioning of the union aspect. That's why otherwise
my instruction is that the union is function proper
the question of the issue of encroachment and the issue whether with regard to encroachment has not yet been framed. The local investigation was premature. Direction for local investigation was premature. This is not a case where but construction has to be seen.
And I'm claiming
It-
title over the property.
No, but local features then maybe.
First
it
of all,
should be
Milord,
out of
my
Article
deed
2(7).
and their deed has to come to surface. It has to, Milord.
I
court-
agree that
court
one
is-
property, both claiming title, the question of eliciting dispute doesn't arise because it is not a boundary dispute or something that by demarcation it can be sorted out. It is not that overlapping claims. It is entire you are claiming, entire they are claiming. That part fine, but what about this construction part?
No, construction part, Milord, if ultimately,
Local feature and construction
no,
can
if
be seen.
ultimately, Milord, if the Milord decree is passed, Milord, automatically that
No,
will
then
go.
in that case, so there will be never be any inspection
No,
or
Milord,
investigation.
I don't say that. I say this is premature because, Milord, the issue regarding, Milord, encroachment has not been framed, Milord, because the court may not frame, because they are claiming, we both are claiming rival title over the property. Court may not frame issue regarding encroachment.
No, but what is the problem in seeing the local feature?
But this is not such an application, Milord. Construction with regard to encroachment, ultimately it touches the question of encroachment.
Any injunction was passed.
I have to check up there. I cannot say immediately, Milord. I have to check.
Anyway, let this matter appear on. It is neither a case of boundary dispute nor a case of encroachment over a over a portion of the suit property or a portion of the property of the plaintiff. Thus, local investigation in order to demarcate, measure and demarcate the co and co scheduled property. No, wait 1 minute. What is the co scheduled property?
Cost schedule of the plaint, Milord.
Yes.
And it comes to the plaint at page 9, Milord. The kindly comes to page 13. Entire 425 by 1191, which I am also have a Milord claiming title.
Or kho?
Kho is, Milord, the encroached portion.
So there is an encroached portion.
No, kindly see, Milord, kho schedule. জেল আমার নালিশি 7 শতকের মধ্যে 2 কাঠা জমি সম্পত্তি. The Milord, 2 kathas cannot be, Milord, encroachment.
Why not?
But 2
Why not?
kathas
It
cannot be
can be
encroachment, Milord.
Cannot be. Why?
Kindly see what is the case. He says নালিশি prayer, kindly see নালিশি ক ও থ তফসিল ভুক্ত সম্পত্তিতে বাদী সত্য সাব্যস্ত বিবাদীগণ যাহাতে বাদীর খ তফসিল ভুক্ত জমিতে খাস দখল অতে এবং
He is claiming for title over ko and says around 2 kathas you have encroached. So that can be done by local investigation. Why not?
investigation not at this stage.
Why?
Not at this
Doesn't
stage.
matter.
Because I have a Milord rival title over the property. Will you kindly see 425 by
You are claiming
1191.
rival title over that encroached portion. So why cannot
Milord,
there be local
kindly see, Milord,
investigation?
kindly see my entire, Milord, kindly see, Milord, page 27. Kindly
no.
see, Milord,
Nothing.
kindly see page 27.
Yes.
Kindly see, এই বিবাদী নালিশি সম্পত্তিতে ওয়ারিশগণ সূত্রে, খরিদ সূত্রে, দান সূত্রে মালিক হইয়াছে। এই বিবাদীগণ সম্পত্তিতে অর্থাৎ 4251191 দাগে এবং পার্শ্ববর্তী 4251190 দাগে জমিতে একতালীয় ভাবে বাস্তুবাটি করিয়া সত্যবান দখলিকার আছেন এবং এই বিবাদীর নামে নালিশি সম্পত্তিতে মিউটেশন করিয়া নালিশি সম্পত্তি বাস্তুবাটিতে দখলিকার আছেন। I do not say any specific portion.
দুই শতক, দুই কাঠা কোথায়?
No, no, plaint case is 2 kata.
দুই শতক, come to
Schedule,
schedule. Schedule 4251191.
2 kata,
কোথায়
7
কাঠা?
শতকের দাগের 7 শতকের মধ্যে পশ্চিম দিকে 2 কাঠা সম্পত্তি। And I have declared আদৌ বেআইনি দখলিকার নন।
ভুল ও ভিত্তিহীন হইতেছে, ব্যতীত পাইতেছে আর এস জমির পর্চায় দখলকার যে রেকর্ডিং হইয়াছে উক্ত ভুল ও ভিত্তিহীন নালিশি সোয়েন্স দাগের ভূমিতে এই বিবাদীগণ মালিকানা সূত্রে সত্যবানের এই জমিতেও বেআইনি দখলি নহে বা এই যত বিরুদ্ধে খাস দখলের ডিগ্রি পাইতে হলে no, so after this he can frame an issue also.
As of today, neither my deed nor the deed of the plaintiff has come into the before the court. Court on the allegation as stated in the plaint has allowed this application, which I have denied.
All right, কি বললাম? At this stage, before the rival claims of the parties are available on the basis of evidence, may be premature. Service upon the opposite party, as also the learned advocate appearing on behalf of the opposite party. Affidavit of service to be filed on affidavit of service on the next day.
তারপরে
কবে থাকবে এটা?
এটা কয়েকটা পরে
Where is this বারুইপুর?
বারুইপুর
কবে অবধি দিয়েছি স্টে? 31st August করেছি না? স্টে অফ অপারেশন অফ দ্য অর্ডার ইম্পিউট আপ টু August 31 করে দিন। Matter appearing on to appear on August জুলাইতেই হয়ে যাবে। 5th July at 3 p.m.
5th July at 3 p.m.
Yes, come. এটা প্যাড দাও না, নোট প্যাড। Yes, next. Continue. Yes.
Expeditious hearing of a title appeal, pending since 1999. Now, what happened, to Order 22, Rule 9, my predecessor in interest was the original party. Substitution after setting aside abatement is filed. The appellant, are cross-examining me on that. That is going on, since 2012. Miss case is going on since 2012.
মানে against an order of injunction appeal.
No, title degree, final title appeal.
Miss case is that order 22. Alright,
That
take
was
down.
filed in 2002. That is also going on.
This application has been filed for expeditious disposal of title appeal number
35 of 1999.
35 of 1999, along with miss case number 1 of 2012, pending before the learned additional district judge at Baruipur District 24 Pargana South. Considered the having considered the records, this court finds that the miss case has been pending since long. The prayer of the petitioner is innocuous. Neither party stands to lose if a proceeding is disposed of expeditiously. This court has not expressed any opinion on the merits either of the miss case or of the pending title appeal. The learned court below shall dispose of the miss case within a month from the next date fixed, and thereafter proceed with the disposal of the title appeal within the next 6 months thereafter, within the following 6 months thereafter. Full stop. A copy of the revisional application along with a copy of this order be served upon the opposite parties and or their learned advocates contesting the matter in the learned lower appellate court. আচ্ছা যেখানে বললাম innocuous and nobody can be heard ওখানে, hence disposal of this revisional application does not require service of prior notice. Yes.
পৌঁছি আমি 24টা করে আসতে হবে
Yes.
12টা
হ্যাঁ পাসওভার গুলো ডাকো। সবার আগে যেটা প্রথম থেকে ডাকো যেগুলো পাসওভার হয়েছে, সবই তো 12টাই হয়েছে।
But I beg to appear on behalf of the petitioner, my lord.
Yes.
My lord, I tender my unconditional apologies, your lordship. I appear on behalf of the respondent opposite party number 1, your lordship. My lord, the confusion, my lord, that has happened, your lordship, on the last occasion, my lord, Mr. Banerjee appeared on behalf of opposite party number 2, who was appearing since 2022. My lord, since my learned senior friend was appearing, my lord, we refrained from appearing in the matter, your lordship. Moreover, your lordship, no objection was also obtained by my client, your lordship, from Mr. Banerjee.
That's okay. I know that. Mr. Banerjee told me that.
Yes, my lord.
But kindly once not first look at.
দেখি দাও তো।
My lord, I would humbly seek, my lord, an adjournment because we were not following the list, your lordship, and my lord, we were also not prepared in the matter, your lordship, as on today, my lord.
Let me
Kindly once look at
Read to me.
not 37. Section 2, subsection 37. But here your lordship will find that product seller in relation to a product means a person who in the course of business imports, sell, distribute, lease, installs, papers, package, label, markets, repairs, such and such involved in placing such product for commercial purpose and includes a manufacturer,
marked X for identification. However, kindly see, the said document was not certified copy and the documents did not bear the official seal and signature. Moreover, when the plaintiff is unable to produce the primary evidence of the original document and the same was not tendered by them, so the document cannot be marked as exhibit. And learned counsel of the defendants already raised strong objection against the instant petition. Plaintiff Rajneesh Kumar Malhotra and others registered the instant petition by filing written objection on 21st November 2022, inter alia submitting that the instant petition is not maintainable and Malafide 1. The application of the defendant has not been properly signed and all the allegations are false and baseless. The said documents are duly tendered by the plaintiffs through paragraph 8 of the affidavit in chief was executed by way of due procedure of law. Stating the above, they plead before this court to reject the instant petition. Third, peruse the petition, written objection, and exhibit concerned along with the deposition and other materials on record considered. Now, from the deposition of the plaintiff side, it appears that only a true copy of the root. Milord, this is kindly, Milord, keeps it in mind, this is not a certified copy. This was a photocopy of the certified copy, which has no, Milord, cannot be considered, Milord, as a secondary evidence. Produced by UDC of ADSR, Alipur has been marked as Exhibit 6, and this is with objection. It cannot
Will
be.
you give them notice? I'll keep it tomorrow. Let this matter appear
Wednesday.
or Budhbar din. Further notice be issued upon the learned advocate for the caveator. Suitটা কোথায়?
Baripur.
So you can't inform the learned advocate in the court below, na?
Then
Try to give an
on the
information.
caveator,
Caveator I've given.
Achha, very well. Very well.
Learned advocate for the caveator I've given.
Very well.
But
If possible, I will try.
just try and inform. Yes, next.
Particular phone number টা নিয়ে নাও তো ফটো তুলে নাও না চিঠিটার একটা ফটো তুলে নাও ফটো তুলে দিয়ে দেবে একটু
16, my lord, I am for the opposite party, my lord. My lord, learned counsel, Mr. Nilanjan Bhattacharya, appearing for the opposite party, my lord, due to some medical difficulties, could not appear, my lord. He will be appearing on 2, my lord. If your lordship be kind to fix this matter at 2 o'clock, then it will be fine, my lord.
What is the matter? 2. All right, 2 p.m.
Tomorrow kindly takes it up.
Not today. Tomorrow, please come.
Grateful, my lord.
My lord, this is my application, my lord.
Yes.
My lord, the plaintiff degree holder is the petitioner before your lordship, my lord. Suit for specific performance and contract, my lord. There is a suit for specific performance and that was degreed in a compromise.
What is your
My lord,
order impugned?
order impugned is, my lord, that is annexure. And that is, my lord, last page, my lord. In a the degree is put into execution, my lord. In that execution, my lord, during the pendency of the execution proceedings, my lord, although the suit was decreed in a solenama and the petitioner has paid all the consideration money to the petition interest of the opposite party number 2 to 10, my lord. And the execution case was filed further in 2013. After giving the notice, my lord, it is their case that they have sold the property to the others. And there is no provision that the degree holder, the judgment debtor could not sell the property after the compromise degree was passed. But they have sold the property and they have filed an application, my lord, the subsequent purchaser for that is their application.
Order 21.
Yes, my lord, order 1, rule 10, my lord, they have filed. And my point is this, my lord, they have no right to file execution proceedings, but they are not the party in that proceeding.
Maybe, but what about order 21, rule 101?
My lord, they have.
If third party is affected by a decree, what happens then?
But my lord, third party, my lord, they have a third party
but they have sold, the defendant have sold, opposite party number 2210 has sold the property during the pendency of the execution case, my lord. That is my case. CPC to দাও তো একটু। Their application is, my lord, that is annexure P5, page 27, my lord. They have not the filed application under order 21 rule 101, my lord, but they have filed in order. But they have stepped. But their application is order 22 rule 10, my lord. All right, order 1 rule 10. Order 1 rule 10, my lord. Order 1 rule 10. So they will contest the execution proceeding. If they have, today who will contest the execution proceeding? It cannot go ex parte. Well, may I serve notice, my lord, upon them, my lord? But that application is not proper, my lord. Wait 1 minute. (102) prevents transfer. This is transfer pendentility. Transfer after the suit was filed. No, my lord. After the decree has been passed, my lord. During the execution proceedings, my lord. Execution. Right. Serve and come back. Service upon the opposite party. You added, though you have. Yes, yes, my lord. That he is the opposite party number 1 and others are 2 to 10, my lord. Stay of operation of the order dated September 21, 2022. The court finds that the petitioner has made out a prima facie case as to whether a transferring no, but see, it's a specific performance suit. Yes, my lord. This is a suit for specific performance of contract, my lord. And the suit was they are supposed to execute the deed in your favor. Yes, my lord, the predecessor interests have not been registered the deed. For that reason, the execution case has been filed, my lord. So who is going to register the deed now in favor of your favor? My lord, but the subsequent purchaser of the property. But the application is not proper, my lord. My humble submission. See, if it was a title suit, then it says that the subsequent purchaser who purchases the property pendentility will not have any right, title, and interest. We cannot intervene in this execution proceeding. Yes. But today, if they are not included, who will execute the title deed in your favor? But if they are entitled to, my lord, they have filed the application under your vendor or person from whom, where is the decree? Show me the decree. My lord. There is a judgment, my lord, and that has been allowed by the Lok Adalat, my lord. That is annexure P1, my lord, the judgment, my lord. P1? Yes, my lord, page 13. May I read, my lord? Both the parties have appeared before the Lok Adalat and filed their respective hajiras. One fresh Vukalatnama was filed from the side of the plaintiff. let the vocabulary kept to the record. This is to suit for specific performance of. The defendant to execute a registered sale deed. Yes. In respect of the suit property and terms of the agreement for sale in favor of the plaintiff within 1 month from today. So, and this order will be binding on the person to whom the defendant sold the property. Yes, ma'am. Now, if they are not brought on record, who will execute the deed of sale in your favor? But this is not a suit for possession or title or declaration where the subsequent purchaser pendentality does not have any right to interfere in an execution proceeding for protection of his rights. But they have here. It is a Solenama decree where execution was, court said that deed of sale will be executed in your favor. Yes. By the defendant. Then the defendant sells the property. What will happen now? My lord, but they have not. They don't have any title. How will they pass on title to you then? So that is why they were added as parties, the subsequent parties. But they have party, not the party in the execution. Order 21, my lord. But they have only filed the file order 21 because they are purchasers pendentality. For that reason, my lord, they have. That is, I think, what the law says. Order 21, rule 108 prevents a purchaser pendentality from raising any objection in a execution proceeding. But there is a provision, my lord, 97, my lord, rule 97, my lord. 97, 99 will not, is barred under 108. For that reason, my lord. No, because if your defendant has sold, that is a defective title, then that adjudication has to come. That sale is defective, then that adjudication has to come because that sale will bind these persons. Because this is a sale of the property during the pendency of the execution proceeding, the subsequent purchaser will be bound by that decree or that solenama. That also there are judgments how when a solenama is binding and when it is not. Yes. But anyway, when it was to do something or not to do something, the judgment is there. When the solenama says that there are certain things to be done and not done, oh, now that is for execution. So execution was filed by you rightly. Now, who will execute the decree in your favor, the deed in your favor, if they are not parties? Come back tomorrow. Let me just. My lord, day after tomorrow, my lord. Tomorrow I have some personal difficulty, my lord. Tomorrow next Monday, my lord. I have. My lord, I am on next Monday, my lord. May I come back, my lord? Let me see. 19th, my lord. Perhaps 19th. Next Monday, you want to come back? Yes, my lord. All right. Come back on Monday. Yes, not this week. কি বললাম? না ওটা কেটে দাও। Let this matter appear on সোমবারের ডেটটা দিয়ে। তাই কিছু করতে হবে, not this week মার্ক করে রেখে। কিন্তু আবার এটা লিস্টে চলে আসবে তো? লিস্টে চলে আসবে তো? ঠিক আছে। All right, come back next week. হ্যাঁ বলেছিলাম আমার মনে আছে। না না, বাট সেটা হয় নাকি? কোনোদিন হবে 91টা ম্যাটার হয়ে গিয়ে 7 নম্বর? মানে নেক্সট মানডে, মাই লর্ড। আজকে কিছু বললাম না যে টাইম নিলাম তো।
I am for the petition. Suit for dissolution of marriage, wife is before your lordship. 2016 suit, during pendency of the suit, parties were sent for mediation. And in
Now
court-
what is the stage? You want
husband's
expeditious disposal?
No. Husband's application for order 6 rule 17 has been allowed. I am challenging that order. I have come before your lordship. In course of mediation, husband pay an interim management a sum of rupees 50 lakhs as interim management alimony to the wife petitioner.
Hmm.
Now, by filing amendment application, he is trying to incorporate the fact that that is the full and final alimony I have paid to wife. I
Where
could
is the
not,
order in a mediation?
my lord.
What is the recording of the mediation? Where the mediator files the report?
The report is not with us. That is before
After
court.
mediation, a report is sent back
But
to
that
the
is before
court.
court.
So I have to see what was the, where will I know that that was an interim arrangement?
Mediator can't, my lord, record that. Mediator only whether that has been
No, but the result of the mediation is sent to the court.
Failed. Mediation failed.
only report which we required to file only whether
Mediation has failed.
nothing more, because my lord, we have
Now, out of his own husband has paid that amount towards interim management. Now, taking advantage of the
How will
payment,
the court know that?
there was no order from the court to pay the alimony. Out of his own husband has paid the amount. Taking advantage of the
Whose
payment,
suit is it?
my lord,
Whose suit?
my suit.
You filed a suit
I am,
for divorce
yes,
and you paid for alimony.
I have not. There was no prayer in the court below paying for alimony.
So he has given on his own account 550 lakhs.
Now what he is saying, this is the full and final payment towards permanent alimony.
Say, so how does it matter? That
The
will be
court has-
decided by the court.
If ultimately the suit is my lord, finally disposed of allowed in my favor, if court
So
thinks proper,
mediation was not on the point of alimony.
not at all.
Mediation was on the point of the
Settlement.
matrimonial dispute.
Settlement.
That failed.
That failed.
So that report was returned.
Yes.
Failure of the report, mediation was recorded. Now, husband on his own gave 50 lakhs.
Yes.
Now he wants to say that that 50 lakhs is in full and final settlement. Let him say. That will be proved in that if the court feels that it should be more than that, that is a
But
different
that
issue.
observation I need from your lords.
Correctness of that contention is not the issue here.
If court thinks that I will grant much more amount
Yes,
towards permanent alimony, but here court has fixed the amount, that is the full and final settlement. His
Court
amendment
has
has,
passed the order.
yes, that amendment has been allowed.
Amendment allow maybe.
His
But
contention has
merits
been,
of the amendment is not the correctness of that fact is not allowed when the
kindly
application.
give me an online observation, my purpose will be subserved.
what happened, I'm telling you, lordship. After filing the suit, my lord, he said tight. I entered appearance, filed written statement accompanied with counterclaim. Till today, he has not filed written statement against my counterclaim. Now, my lord, I came up before this court. The wife, there is a direction passed by, husband, there is a direction passed by this honorable court to dispose of the matrimonial suit expeditiously.
Yes.
Now, what happened thereafter? Kindly see the impugned order. The learned trial judge, after that, my lord, at least 10 times, same application has been filed. Kindly see the once the impugned order. But your lordship will find impugned order copy type. Kindly see the last paragraph. Considering the grounds of adjournment taken by the learned advocate for the petitioner wife being more or less the same. And another
Today,
thing,
one minute, Mr. Mukherjee. Today, the husband has filed a WS. Then it is his contention in the WS that I have already given her 50 lakhs as full and final.
no,
settlement.
not that.
That amendment has been incorporated. What is the wrong in there? I can say many things in my suit. I will prove it.
On the contrary, he did not.
That amendment or the fact that he wants to say today when suppose there was no amendment and he says that I have given, did he say I did not pay anything?
So that he has not, he has
Said
said that I have paid
given
the full and final element.
final.
That
So
is,
that whether that is that fact will bind
the-
your client or not is
that
to be
may
adjudicated.
cause prejudice in future in my favor,
Right.
because he will take a place, I have paid the entire amount.
He
So
will
question of further permanent does not
use
arise.
the card saying that no, this was never a full and final settlement
Kindly see my,
because question of alimony was never decided. He paid it on his own and whatever. You will file your additional a rejoinder to
That-
the
that-
written
nothing
statement.
has been filed.
That I will, but
He-
due to illness, I could not. I
But-
was for treatment for long period, my lord.
Yes, yes.
My lord, I filed it.
Exactly.
Kindly see the amendment application, my lord, first page. What I want to incorporate after filing the written statement and the counterclaim, what subsequently happened, that I want to incorporate, nothing more. Till today, he has not filed written statement against my counterclaim. Therefore, he has ample opportunity to controvert the same, and court has to decide. As the amendment is there, that does not mean whatever I have stated that is right. That part I have to prove, and he also, and the court fixed the next date as last chance for filing of written statement.
So you have filed your additional written statement
My lord,
after the amendment. Amendment was allowed.
I have filed the amended,
Written statement.
yes. But he has not filed the initial.
Statement to the counterclaim.
That I will file, but now I am taking steps. My lawyer is appearing regularly. I will take
And
steps.
kindly see the when every time,
The fact that whatever money he has paid, he wants
not
to
only
bring it
that,
on
something
record.
happened. What happened after my lord, the filing of counterclaim, that I want to incorporate, nothing more.
Take
Kindly pass one line observation. This will not preclude the learned court below to decide
No,
the matter.
authority.
If
That's
at all,
obvious.
yes, my.
The petitioner has challenged an order dated November 1, 2020. Oh, no, sorry. Which order?
Order number 29.
1st November,
November 1, 2022, filed by the learned additional district judge, 5th court at, passed by 5th court at Alipur in mat suit number 89 of 2016. By the said application, the application by the said order, sorry, the application for amendment to the written statement and to the counterclaim had been allowed. Trial has not commenced.
no, W is not filed.
Yes,
It
filed
appears on
counterclaim.
the
and-
records that the written statement to the counterclaim has not yet been filed by the petitioner wife. Thus, the suit is at its nascent stage. Secondly, where is the schedule of amendment?
But after that, my lord, you will find.
Amendment application, sir.
That secondly, it appears to the court that the
Subsequent which have occurred, my lord, after filing written statement and counterclaim, I have stated.
that certain facts which occurred after the written statement and counterclaim was filed by the husband was sought to be brought on record, which are factual issues. Moreover, the further fact that the husband had paid rupees 50 lakhs towards maintenance of the wife and daughters as a one-time settlement was also sought to be brought on record. These amendments do not indicate that any admissions are being taken away, or the amendments, if allowed, would change the nature and character of the suit property of the suit. The amendments also do not reflect to be time barred. Hence, the learned court did not err in allowing the amendment. Moreover, the contention of Mr. Chaudhary that the statement that the husband had already given rupees 550 lakhs as one-time settlement for the maintenance of the wife and the daughters. Only wife, the daughters লিখেছে তো।
Two daughters. ওই দুটো মেয়ে আছে
Wife
রে।
and two daughters
এইভাবে মেনশন করে
was incorrect, as the husband had paid the amount on his own accord and the wife did not accept the same at any time as full and final settlement. This court is of the view that the correctness or the merits of the amendment are not to be looked into at the stage of allowing an application for amendment, such whether the payment of rupees 50 lakhs was a one-time settlement or an interim arrangement or a voluntary tendering of the amount by the husband are all to be decided on merits by leading evidence. Have you filed an application on
No,
order
nothing.
24?
Nothing.
তাহলে কোথায় decide হবে এটা?
Why he is saying because he has not
The
filed any.
petitioner does not have any apprehension at this stage with regard to the facts sought to be introduced. All the petitioner is at liberty to controvert all the facts brought in by an amendment, by this amendment, by filing a rejoinder to the rejoinder and or a counter and a written statement to the counter claim.
That direction already there.
আছেই তো।
Yes, last kindly.
And such points shall be decided by the learned court below. It is also on record that the petitioner has not yet filed any application for claiming maintenance for herself and for the daughters. Thus, whether the 50 lakhs, rupees 50 lakhs was a one-time settlement or the court may settlement or not, and or whether the learned court below, if approached, would find a higher amount to be paid, an additional amount to be paid or not, are not to be decided at this stage.
Grateful.
এটা নিয়ে
Amendment.
accordingly
It is
this revisional application fails. Yes, next.
Item number 19, although I am for the petition, I don't know who mentioned the matter. But
Mention did না file করেছে তো।
No,
আজকের date
already order was passed. Kindly keep it in the next monthly list because there is no interim order. In presence of the party.
Aviator, Sanjeev
No, in their presence order was passed. Kindly see the order of Justice Dasgupta.
এটা কি করে এলো? নিউ মোশনের ডিপার্টমেন্ট থেকে আসছে নাকি? আগে হয়ে গেলে আবার কেন?
এটা আগে হয়ে গেছে তো, মোশন হয়ে গেছে ওভার।
কেন? মোশন হয়ে গেছে তো।
Adjournment was for let the matter appear in the after some time.
When do you want it? I'll fix it.
Next monthly list.
one notice, I will hear it out next week.
এমনি মামলা হচ্ছে না, হয়
খারাপ
নাকি?
করে মক্কেল একটু
না না না,
করে
সে
দেয়।
চলে এসছে, ভুল করে কি করা যাবে?
না কেন
next-
ভুল করে আসবে? আমার
না,
ডিটারমিনেশন আছে।
নেক্সট আমি মেনশনই করি নেক্সট। কি দরকার মেয়ে লোকটা?
Weeks I will give you.
নট টু নেক্সট মান্থলি লিস্ট, নেক্সট মান্থ।
All right, let this matter be heard on July 5, 2023 at 3 p.m.
3 PM করলে হয়ে যাবে তাহলে, টাইম লোকাতে পারে।
And the learned advocate for the petitioner is directed to issue notice upon Mr. Sanjeev Daw.
ইনস্টিড অফ 3 PM জুলাই আসুক, কোনো অসুবিধা 3 PM কি দরকার?
এটা কি, how can you stop the court from taking up something, Mr.
in-
Mukherjee? এটা কখনো
নট 3 PM মানে ইনস্টিড অফ 3 PM ম্যাটার
Not 3 p.m. to 30. 3 p.m. come unnecessary at a suit. You are a defendant. Order every matter, order 7, rule 11 has to be filed.
ইনস্টিড ম্যাটার অ্যাপিয়ার 5th July, আই এম গ্রেটফুল টু লট,
Ah, bas,
we-
be grateful, even more. Nothing.
দেন 3:30 মানে ক্যান ইউ গিভ ইট 3:30?
I will tell Mr. Basu Malik to ensure that 5th July there is no 3:30.
তো ইনস্টিড অফ 2:30 গিভ ইট 3:30।
3. Chalo, next. Sanjeev Daker notice this.
কোথায় বসে তাই জানি না।
All right, next matter. any cause of action.
Because that is Sri Lanka Ghosh, and he considers it. It is absolutely trite law, my lord, that the partition suit can only be filed by somebody who is a subsequent purchaser only after asking for possession.
Yes,
My lord, the Silekha Ghosh judgment, my lord, I'm just going through it, my lord. It in respect to that is in family dwelling house, and my lord, it's a joint property. The succession, my lord, Indian Hindu Succession Act, also in respect to that judgment has been, my lord, considered. This is a case, my lord, where these plaintiffs and the defendants have purchased a property in auction through DRT. But this is a business deal. This is not, my lord, probably
Residential building and structure, page 60.
I'll come back. With my respect to my learned senior, this is probably this judgment applies in a case if my brother sells his share to a third party, then section 44 of the Transfer of Property Act is that the third party cannot come into the property because he will obtain an order of injunction. And section 4 of the Partition Act, if a third party file a suit under section 4 of the Partition Act, then the person who is in possession, he can already, he can also sought for that the price which has been sold, he can deposit before the court and he can also get back. That is also a case of preemption. It is a case, there is no relation between the parties. We have invested as amount of money that let us go and
all right, when will you come back? Come back. 1:30.
and this order 7-11 lordship take as per my law senior.
No, whenever. my lord.
Come back considering the judgment. Let me see also.
And only the problem is the evidence of PW1 cannot be proceeded.
let that
And
not be-
5 years,
That-
5 years, I am suffering by investing a large sum of
No,
amount.
this is on order 7/11.
So your predecessor bought the property under?
Auction purchaser, defend my lord, senior friend's client, my lord, and my predecessor, they jointly purchased the property through an auction through DRT.
Now there is a dispute between
Now
the two.
we have dispute. Now these two persons, they sold me the entire share, my lord. Now I have a section 52 lordship knows, my lord.
Mr. Chatterjee, this is not.
Absolutely, this is. Akkebare. I'll show you a lordship on.
And my lord, this is the deed I am also.
Completely. It's a residential property which my learned friend
Maybe,
missed
but
out.
it is not. This is both of you together purchased a property. Subsequently,
I'll
his
satisfy
share
your
was
lordship.
sold. That person was added.
Yes.
That order attained finality.
They have not challenged it.
Now you are
Partition
saying-
suit cannot go on if a person who is not in possession has not asked for possession. That's my point. That is Sri Lanka. Cannot happen.
All right, come back. When do you want it?
But
Whenever your lordship.
Tell me.
any date, my lordship.
নেক্সট ডেটটা কবে আছে বল তার আগে করে দে
কবে আছে date? 30th June is the next date.
বাট এনি ডে বিফোর দ্যাট
Lordship takes.
All right. Twentieth,
Yes, yes.
3 p.m.
Yes, yes.
Let the matter be heard out on June
28
20th at 3 p.m.
28 না 20
কুড়ি।
Oh, great. 20. Great.
3 p.m.
থাকো, আমি রুল।
লর্ড সাহেব আগে স্পেশালি ফিক্স করে 3 p.m. এ নিতেন
বলছি ওইরকম ভাবে আমরা পাঠাতে ফাইল করছি পজিশন ডিক্লার
Upon eviction of a monthly tenant. My lord, in the suit, my lord, I had filed application under section 7(2), my lord. Landlord tenant relationship was disputed, but unfortunately it was decreed ex parte. I had taken out an application under Order 9, Rule 13. My lord, the
Yes.
plaintiff took out an
You must stay within the meantime, order 9.
no, what happened, but unfortunately also, well, during the pendency of this matter,
Order 9 rule 13 heard.
no, order 9 rule 13 has not been heard, my lord, they have taken possession. Now, my lord, so therefore, my lord, the order impugned is blatantly, my lord, illegal on the face of the records. Because I have several authorities also, my lord, that order 9 rule 13, my lord,
Yes, all right. Now what they've
Now,
done-
my lord, at this stage, my lord, third party interest should not be created, my lord, and order 9 rule 13 may be disposed of, my lord, expeditiously.
Order 9 rule 13, my lord, someone has not yet been served, my lord.
But they are appearing.
Yes, yeah, I will
Yes.
give you that you have noticed. He will
Lord
serve
Chief,
you. Yes.
they are
take it.
evading summons in the court below.
Order 9 rule 13 pending execution will not be stayed.
My lord,
Minimum-
order 9 rule
minimum-
13, my lord, let me,
minimum stay. Same court is hearing.
my lord, let me hear for a moment, my lord.
Yes, yes.
Order 9 rule 13 along with the section 5
Hmm.
is pending, my lord.
Hmm.
It is pending since 2018, my lord.
Hmm.
They have not yet been served the summon on us, my lord. In the meantime,
All
possession
right.
has been handed over.
All right.
They are
now I
evading no-
cannot do anything without with the possession being handed over, but you will not change nature and character and alienate the property till the order
Lordship.
13 is
My
out.
lord, repairing is required, my lord. Kindly will not transfer it to anybody.
It's a small shop room, no repairing is required at this stage.
The order dated March 24, 2023, passed in title execution case number 14 of 2018 by the learned civil judge junior division 2nd court at Burdwan is under challenge before this court. According to the learned advocate for the petitioner / judgment debtor, the during the pendency of the application under Order 9, Rule 13 of the Code of Civil Procedure, read with Section 5 of the Limitation Act, the learned court below refused to stay
Lordship.
the execution proceedings and directed that the title execution
To
case
proceed.
number 14 of 2018 would proceed in accordance with law.
My lord, the stay petition is of 2020, January 2020, my lord. They have not stay petition for applied for the stay in the year of 2018, my lord, when they have
All right.
come up with the execution. My lord.
Twice stay petition has been filed, both the petitions I have annexed.
Denies such the contentions of the learned advocate for the petitioner / judgment debtor and submits petitioner na petitioners
Petitioner. Sole petitioner.
and submits that title suit number 88 of 2014 was decreed ex parte on
On 12th April, my lord.
12th April.
April 12, 2018. Although an application under Order 9, Rule 13 of the Code of Civil Procedure, read with Section 5 of the Limitation Act, had been filed, thereafter, no steps had been taken by the judgment debtor / petitioner to proceed with the same. It is further submitted that even the summons have not yet been received by the opposite parties. Hence, the learned court below had rightly rejected the application for stay, which was filed after 2 years from the decree.
No,
passing
no,
of
no.
the decree.
It was filed, my lord, within 1 month.
Oh,
No, my
filing
lord.
of the-
Yes, yes. My lord, kindly sees. My lord, section. My lord, this is the.
So 20. Anyway, next paragraph. Mr. Rai, learned advocate, submits that denies the factual allegations made by the learned advocate for the opposite parties. Next paragraph. Having perused the records, it is an admitted position that the application for setting aside an ex parte decree upon continuation of a delay is pending before the learned court below since long. The learned court below, in all fairness, ought to have stayed the execution proceeding for a limited period, and the proceedings under Order 9, Rule 13, read with the application for, and the application for condonation of delay, as also the application for setting aside ex parte decree if if the delay was ultimately allowed, was ultimately condoned, ought to have been disposed of first before, and the execution proceedings ought to have stayed for a limited period, had to have been stayed for a limited period. This court is of the view that unless the stay is granted, was granted, the pending applications filed by the defendant who suffered an ex parte decree would become infructuous. Next paragraph. It is further submitted that the possession has been taken in the execution case. Hence, the only interim order that can be passed to safeguard the rights of the defendant, judgment debtor, is to restrain the decree holder, plaintiffs, decree holders, plaintiffs from changing the nature and character of the suit property and or alienating and transferring the same.
Not to create it, except
No
repairing, my
third-party
lord.
rights shall be created
Lordship.
in respect of the property in question. Such interim order shall be operative for a period of 4 months. Within such time, the application for under Section 5 of the Limitation Act and the consequent proceedings for setting aside an ex parte decree, if the application for condonation of delay is allowed, shall be disposed of by the learned court below. A copy of the application under Section 5 of the Limitation Act and under the application filed under Order 9, Rule 13 of the Code of Civil Procedure, which the opposite party is alleged not to have received, shall be served upon the learned advocate on record for the opposite parties appearing in this case before this court within the course of this week. Such service shall be taken as good service and no further service of summons would be required
In the court below.
through the learned court below.
Grateful, my lord. My lord,
This order is
liberty
being
to
passed only to expedite the proceedings before the learned court below. The opposite party shall be at liberty to file the written objections to both the applications within 2 weeks from receipt thereof.
grateful, my lord. Liberty to repair, my lord.
No.
Kindly, my lord. Grateful, my lord.
Not needed. Next matter.
I am for the opposite party. On last occasion, direction was passed on the petitioner to serve a copy, my lord,
You.
on me, my lord. But other side, my lord, I think, my lord, the petitioner is not keen to proceed with the matter.
Why you say so?
Lordship sees last occasion also they did not appear. Today also not.
Oh, none appears on behalf of the petitioner. No accommodation is paid for. Stop on June 6, 2023 as well. None appeared on behalf of the petitioner. Let the matter be dismissed for default.
Grateful, my lord. Much obliged.
Check the list till 4:30 today. Check the list once tomorrow. If they come and pray till 4:30, I will recall my order. Yes.
Lord, 24, I beg to appear on behalf of the petitioner, Lordship. My lord,
Hmm.
this matter, my lord, there was a liberty granted, my lord, to file the suit afresh, my lord, to the plaintiff. My lord, I was for the defendant. My lord, that liberty was a conditional one that's subject to payment of cost of ₹400. Now, my lord, the plaintiff, my lord, again filed the suit, my lord, on the self-same cause of action, my lord, without complying, my lord, the court's order. Now, Lordship, kindly consider page 51 for a moment. That was the earlier direction passed. My lord, 31st of July's order, my lord, 2021.
Page 51.
Page 51 of my revisional application, Lordship. My lord, since there was no prayer for recovery of possession, my lord, court, my lord, granted liberty, my lord, that liberty was conditional. But, my lord, this condition was not fulfilled. Again, my lord, the petition was filed. Lordship may kindly peruse this, my lord. I have annexed all the order sheets, my lord, the certified copy. From order 1, your Lordship will get, my lord. There was presentation of plaint with deficit court fee, nothing paid. and my lord, it was proceeded with, and ultimately by virtue of the order impugned, my lord, my lord, filed a petition praying for, my lord, rejection of the plaint because of non-maintainability, my lord, on twofold grounds.
Maintainability or non-compliance of court's order?
Non-compliance of court's order, as well as, my lord, another ground was, my lord, since, my lord, it was filed against a death, my lord, person. Now, lordship, kindly consider, my lord, 4th of April's order. My lord, court in fact tried to cure the order, my lord, by virtue of, my lord, granting him liberty, my lord, to deposit the cost before the SDSLA, which is, my lord, to my humble submission, is incorrect. Because, my lord, once, my lord, the suit was, my lord, withdrawn with a liberty to file afresh, subject to payment of cost, my lord, that is exactly, my lord, in compliance of Order 23, Rule 1, Sub Rule 3. Now, my lord, once that condition is not fulfilled, my lord, the second time, my lord, the presentation of plaint as well as, my lord, the suit was filed, my
And
lord, that is,
cost should have been paid.
yes, my lord, that is a total irregularity, and, my lord, should not have been registered. That is my humble submission. It cannot be, my lord, cured, my lord, subsequently. Now, my lord, by way of a subsequent order, court has, my lord, granted him liberty, my lord, to deposit the cost, my lord, which is, my lord, my humble submission is incorrect. My lord, once, my lord, the
Discretionary order.
my lord, the difficulty is, my lord,
Why will, suppose today you said the suit will be liberty to file a fresh upon payment of cost. He files a fresh, he doesn't pay cost.
my lord, then, my lord, the liberty goes. My lord, liberty was coupled with, my lord, the cost portion. So, my lord, he cannot avail, my lord, the liberty in one hand without paying the cost.
It's a discretionary order.
My lord, lordship, kindly see, my lord, subsequently, it was, my lord, my lord, my lord, it was, my lord, liberty was granted again, and, my lord, my lordship, 4th of April's order, lordship, kindly see,
Page?
my lord, the order impugned, lordship. This is, my lord, the last order of the order sheets. My lord, we are specifically, my lord, pleaded by way of filing a petition that this liberty was not exercised as per, my lord, the condition. And, my lord, court in fact, my lord, granted him again, my lord, liberty by way of, my lord, depositing, my lord, directing him to deposit the same before SDLSA. Before that, my lord, at least 11 substantive orders passed. Commissioner appointed, everything happened.
This is a curable defect.
My lord, my humble submission, my lord, I'll just argue, my lord, on the lordship, kindly grant me liberty to put them on notice. My lord, I'll come back with decision. My lord, if the, my lord, liberty is granted, my lord, which is a conditional one, if the condition part is not fulfilled, my lord, the party cannot avail of that liberty.
Suit was filed when? Second suit?
Second suit filed, my lord, in the year 2021.
And the cost was offered when?
Lord, cost was offered 31st. No, cost was never paid.
Only after you filed that?
Yes, yes. Cost was never paid. If, my lord, his bona fide was there, I would not have disturbed your lordship. Lord. They have not filed, my lord, the cost portion. Now, lordship, kindly see, my lord, the previous orders.
Discretion of the court to see whether that condition not having been met could be met and cure the defect.
My lord, may kindly peruse.
Not a non-curable defect.
My lord, my humble submission, this is non-curable. Lordship, may kindly peruse Order 23, Rule 1 for a moment. My lord, when suit is withdrawn, my lord, and liberty is given. Probably, my lord, Sub Rule 3.
Yes, on such condition.
Yes. So, my lord, if the condition is not fulfilled.
Condition, you said he didn't fulfill, court said, all right, I'm allowing belated
But, my lord,
fulfillment of the
before
condition.
filing,
Why will that not be a curable
my lord,
defect?
before filing, they have to fulfill the condition. That is my humble
There
submission.
is that.
My
Why
lord,
can't
that
that
is, my
be?
lord, apparent from the order sheet itself, page 51. Page 51, Lordship, kindly see, my lord.
Go for that. Now, Jashoda.
Lord, the
And
amount
this
I am not,
Point was raised by you when?
my lord, I have raised, my lord, by way of filing a non-mandatory petition.
Months from filing
No,
of
no,
the
immediately,
suit.
immediately.
Where?
Lordship, my lord, I have annexed, my lord, my petition at page
You serve, but I don't think this is the
Page
discretion
52, my
of the
lord.
court.
Page 52, my lord, my petition. My lord, I have taken two full grounds. My lord, one is, my lord, against a dead party. My lord, they have filed, which I am not
But
taking.
it's already on record.
Yes, his legal heirs are on record.
You spoke.
That point I am not, my lord, taking. But,
Yes.
my lord, regarding the cost part, page 52, Lordship, kindly see. My lord, in spite of my filing, my lord, Lordship, kindly see, my lord, assuming, my lord, court has granted liberty to a party, my lord, to cure a defect, my lord, post filing of a suit. My lord, if that defect is not cured in spite of granting liberty, my lord, that attracts order 7 rule 11.
But that
Claim should be
when it
rejected.
was attracted to the notice of the court, it was paid.
My lord, that is, my lord, with regard to that should be, my lord, a simultaneous one. My lord, it cannot be, my lord, that liberty once taken, thereafter, my lord, cost file. It is not, my lord, perhaps, my lord, it is not that, my lord. Order 23, rule 1 says, my lord, condition has to be fulfilled.
It says the court can allow upon some such condition.
My lord.
So condition
My lord,
imposed.
condition imposed and condition not fulfilled.
No, this is a curable defect.
My lord, I'll just, my lord, take your lordship's leave. My lord, lordship, kindly grant me liberty to serve. My lord, I'll come back with decision.
Yes, sir, you come back.
Then, my lord, lordship,
It
kindly
is
keep it, my lord, after.
I'm sure this has to be a discretionary
My
order.
lord, 23, rule 1.
I allow you to withdraw a suit, file afresh upon imposition of cost. You file the suit before me? Same
Yes,
court?
yes.
And I find that, well, you say cost was not paid. I cured the defect in the suit.
Because lordship is sitting, my lord, lordship is sitting in, my lord, 226, 227 jurisdiction, my lord, it can be done. My lord, but, my lord, suit, my lord, 23, rule 1 is the governing provision.
These things are all curable.
My lord, I'll just come back. Lordship,
And
kindly
these are
keep it, my lord, next week.
of the court.
Lordship, kindly keep it, then, my lord, in the next week. I'll come back with the decision.
Come back. Serve and come back then.
Lordship.
Service upon the opposite party. How many are there?
My lord, only one, sole opposite party.
Pathor Pratima. Let the matter appear on. When can you come back? 26 June
Lordship,
under the heading motion.
Lordship, grateful, my lord.
I beg to appear on behalf of the petitioner.
Mm.
Legal heirs of the original plaintiff, sole original plaintiff, is the petitioner before your lordship. The original plaintiff, my lord, sole plaintiff, died on 24th of August 2019.
Hmm.
But the substitution application captioned as Order 22 Rule 3 that was filed on 2nd of December 2019. So as per Article 121, the initial period is 90 days and for setting aside abatement again 60 days. So it is, my lord, here, my lord, 8 days after the 90 days. So application not captioned as Order 22 Rule 9, but Order 22 Rule 3. But, my lord, if your lordship kindly once takes pen, page 18, application starts, kindly turns over page 19, paragraph 2 and paragraph 3, my lord, kindly once peruses. I will not place. It is an application where the reasons for not providing or not filing the application within the period of 90 days is being mentioned. Now, my lord, the Honorable Supreme Court has made it clear, my lord, in 2003 itself, that if an application, in the body of the application, the causes for which the presentation of application has not been made within the period as prescribed, as in this case, 90 days is being mentioned, then even if the application, the prayer for setting aside abatement is not being prayed for, but the application has to be treated to be an application as if it has been preferred with a prayer for setting aside abatement. That is 2003 volume 10, page 691, specific. So by wrong caption, that I have captioned it as order 22 rule 3, the court cannot reject my application, treating that I will have to file a fresh application under order 22 rule 9, because this has been filed in 2019. Today, in 2023, if this application is being rejected for non-captioning it as order 22 rule 9, I will again have to explain everything. And that is the specific law is paragraph 8 of this judgment.
Serve and come because
Not only one thing, this is a suit for eviction of licensing. I am all along enjoying an order of injunction so that he cannot make any construction over the property. In view of dismissal of this application, my suit goes. So whatever interim order I was enjoying, let it be revived, continue till the disposal of or your lordship specify any day. I will come back.
the prayer for upon setting aside amendment, that extra line is not there.
Yes, and Honorable Supreme Court said if in the body of the application, the explanation is being provided, then he ought to have treated the application as if it is an application for setting aside amendment.
All right, service upon the plaintiffs, upon the opposite party. Status quo with regard to the nature and character of the suit property up to July 31, 2023, or until further orders, whichever is earlier. Next.
For the petition. This is from an exclusive disposal of application for injunction. I am the defendant in the suit, my lord. But there was an order of consumer forum, my lord, in my favor, my lord, for providing water connection, my lord. Now, my lord, because of the ad interim order of injunction, my lord, the HMC could not provide that. And I have challenged that order before the appellate court below, my lord.
Wait, what do you want to be expeditiously heard out?
My lord, order 39 rule.
Pending in the trial court?
Yes, my lord.
All right, take down.
And the Miss Appellate Court, my lord, was pleased to direct, my lord, appoint a commissioner, and my lord, pleased to direct the court below, my lord, to
dispose of the application as expeditiously as possible. Thereafter, my lord, one order 1 rule 10(2) was filed by the plaintiffs. That was allowed. Now they have, my lord, I had a counterclaim in the suit, my lord. Now they have filed an application under order 7 rule 11. Now the court has fixed hearing of that. My lord, in this way, my lord, the application for injunction is being, my lord.
So if the court has fixed hearing of that and you want preponement of this before the order 7 rule 11, then you have to serve and.
No, my lord,
that
what
will
I want.
become a prejudicial order, isn't it?
No, my lord, what I want, my lord, that, my lord, my application may be heard, my lord.
I'll say it should be heard expeditiously, but no, I can't say before the order 7 rule 11. That if I say that, and I'm actually altering an order of the court.
No, it can be along with that application too, my lord. Subject to what my lord deems fit, my lord.
That along with, I can give the court, what is the next date fixed for the order 7 rule 11?
That's, my lord, 12 July.
So I can direct order 7 rule 11 to be disposed of within a certain time, and then, because if I bring it before that, then
That's my counterclaim. That has nothing to do with the application for injunction, my lord, filed in the suit, my lord.
it is true that in order 7 rule 11 does not need to be heard before the injunction, but if the court has fixed it, court has fixed it.
My lord, both can be disposed of together, my lord. In the meantime, I'll file a put up and, my lord, inform the court.
Disposal of order 30, the application under order 39 rule 1 and 2 of the code of read with section 151 of the code of civil procedure, pending before the learned, which has been filed in connection with title suit number 1579 of 2019 and is pending before the learned civil judge, bracketed junior division, 6th court at Howrah. Learned advocate for the petitioner submits that despite there being an order of the honorable the learned lower appellate court with regard to expeditious disposal of this application and for injunction, the learned court below has failed to hear out the application and instead has fixed an application under order 7 rule 11. Has fixed an application under order 7 rule 11 of the code of civil procedure for hearing. Without going into the merits of the allegations made by the learned advocate for the made by the petitioner, and without going into the merits of the claims and counterclaims of the parties, this revisional application is disposed of with the direction upon the learned civil judge, junior division, 6th court at Howrah to dispose of the pending applications in title suit number 1579 of 2019 within a period of 4 months from the next date fixed. As an innocuous prayer for this early disposal of the pending applications has been made, and in view of the fact that expeditious disposal of any proceeding is beneficial to both the parties, prior service of notice upon the opposite parties before disposal of this suit, this revisional application is not required. Tarpore, the petitioner is directed to serve a copy of the revisional application along with a serve a copy of this order upon the opposite parties, plaintiffs within the course of this week.
If it can be, my lord, 2 months instead of 4.
I
will give a try, my lord. That is after the next date, my lord. 1 month still left, my lord. But
you have only filed. Who's filed?
No. The plaintiffs have filed to my counterclaim.
Your counterclaim. All right.
2 months, my lord. I'm without water, my lord, in my premises.
You could have asked for modification. Order 39 rule 4.
I've asked, my lord. I've challenged it, my lord.
Where you have asked?
Before the misappellate court below.
Appeal court also didn't give you water supply. Then
No, has asked the commission to file report for the court below.
Next.
My lord, tenant's application.
What?
Tenant's application, my lord. 7.2 and 7.21 was filed, my lord, after expiry of time.
Then?
And my lord, section 5 does not apply. That is law now. My lord, I have to.
So rightly rejected.
Causing injustice.
Chamaria's case, Supreme Court has decided now, and
My lord,
can be done.
2 things. One, my lord, section 40 of of West Bengal premises taxation has not been considered
In the Supreme Court,
by not considered. Section 40 ওটা তো section 40 তো
এ
That-
দেখি প্রেমিসিস টেন্সি একটা দাও তো,
my lord
কোথায় গেল? কেন তো ছিল?
my lord, Section 5 has been made applicable to a proceeding. That the entire thing, my lord, court has to consider whether the application under 7(2) or 2(1) is a proceeding with the meaning of the act. My lord, I have
Proceedings and appeals. But 7(1) and 7(2),
my lord, subject to the provision of this act relating to limitation, the provisions of Limitation Act 1960 shall apply to proceedings and appeal. And my lord, 7(2) is a proceeding,
yes, but subject to the limitation under this act.
subject to,
And
and my lord,
7(1),
limitation, my lord, is 5, my lord, 1 month, 30 days. But there is scope, if section 5 applies, it
no,
can be
but the
extended.
court has said that limitation, period prescribed
Unless
under
there is a bar.
7(1).
Unless there is a bar in
Now, the
7.
Supreme Court has interpreted 7(1) in a way that the period fixed is mandatory
Yes.
and there is no scope for the court to apply the laws of
Manoj,
limitation.
mandatory is not ready. Mandatory is the condition, not the application.
But
My lord, kindly visualize.
but I cannot distinguish a Supreme Court decision
No, but non-application of 40.
by the learned trial court.
That court
I can't
did,
say that because Supreme Court has clearly said.
my lord, kindly see,
Supreme Court has taken care of 40. That is how you have to
Supreme
agitate
Court
there.
is saying, my lord, the condition is mandatory.
Section 5 will not be applicable for delayed deposit that has been held by the Supreme Court. Yes,
Condition, my lord, or
give me the Chamaria's judgment.
yes.
Court cannot condone delayed deposit, which means condone by application
Because
of
the
Section 5.
condition cannot be.
Then what?
So
what can
nowhere,
be?
my lord, it has been stated section 5 doesn't apply. The condition is mandatory. What will happen when the condition nowhere says.
Why? BP Khemka is the decision where Section 5 was made applicable. That was distinguished. in the Supreme
Khemka's case
Court.
is under old act, my lord, I am not on.
Perimeteria, 7(1), 7(2) is perimeteria.
Then section 5 applies.
No, no.
My lord, take one example. A tenant deposits the money, but does not file the application for condonation of delay. Does not file application under 7(2). After expiry of 2 months, he files. Section 5 will not be applicable. My lord, a question.
I can be sympathetic.
Court says the condition is mandatory, not the section 7(2). Condition is mandatory. Payment is mandatory. If I say I am not a defaulter, then the condition doesn't apply. On 2 conditions, I paid the money, but I do not file the application under 7(2). Whether after expiry of time I can file 7(2) application. Second, I say I am not a defaulter, adjudicate. Then I need not pay the amount.
No, but have you said that? Is this a case where you have paid all the arrears?
Uh.
Is it a case where you are not in arrears? Because if you
That
have
is,
paid
that is,
everything,
my lord, that
in
is my
that
case.
in
That
that case,
that is my case, my lord. I am saying my deposits with the next question comes. I am depositing the amount with the rent controller.
Hmm.
In spite of this. And my lord, again,
deposited with the rent controller when?
before, after suit.
So all the area rents have been paid by
My
you.
lord, that is. My lord, kind page. In this case, my lord, condition is not available, is applicable. আছে চালানগুলো আছে
You have to show that the area rents have been paid within a month from the receive of summons or when you appear.
If I say I don't have any area, then I need not pay.
Then you need not pay. Then you should not be aggrieved also.
No, I can file an application. My payments before the rent controller are adjudicate, whether that is a proper or not. Because, my lord, your lordship will kindly see that rent controller has been deleted from the new section. Only to landlord and
Civil code.
again, my lord, section 20. Section 20 says a tenant can deposit. These aspects were not gone into, my lord. আর তো কিছু বলার আছে? I have exhausted. Well, matters should be harsh in my opinion. All aspects.
True, but
All
with the Supreme
aspects.
Court order, it will be very
All aspects.
not proper for the court.
Because payment to the my lord, rent controller, my lord, section 20 says a tenant can. Till degrees first, I have a right to deposit with the rent controller. And entire rent has been paid to the rent controller. Best example I have stated, madam, I deposited I admit the area and deposit, but I do not file the application under 7.2. Whether section 5 applies or not. If we apply this test, my lord, it doesn't apply. All the payment may be mandatory, not the application.
Let's see what is the order impute.
Not maintainable.
Not meant.
My lord, following the Supreme Court judgment and our High Court judgment. First, section 5 rejected, then 7.1 and 7.2.
Take down. The petitioner is aggrieved by an order dated March 3, 2023, passed in ejectment suit number 228 of 2022 by the learned Chief Judge, City Civil Court at Calcutta. In ejectment suit number বলেছি না? By the said order, the application under section 7(1) and 7(2) of the West Bengal Premises Tenancy Act filed by the defendant petitioner was rejected. The rejection was on the ground that but Mr. Bakchi,
Yeah.
look at this order.
Yes.
The court has found that the current deposit as required by the statute 7(1) month
Yes.
by month within the 15th of the month was not paid. So what you are arguing
So the kind,
that the arrears
no,
were paid by me.
in the court. In the court, because I was not permitted.
Come to
All current rent is being deposited with the, and that is my application, adjudicate.
this is the last two and 2 November.
All challenge.
কাণ্ড কারখানা, একটা court থেকে বুঝে বুঝে।
My lord, kindly 7 to kindly 10. My lord, kindly, my lord, page 12. Prayer portion
No,
of.
but another thing, why will you, after the act has come into force and you have received the summons,
My lord, they are.
why will you keep depositing in the rent control when the law
was,
says otherwise?
that is to be adjudicated.
No,
And my lord, to that I section
that
20,
is not.
that is to be adjudicated.
To
I
be
say,
adjudicated is,
that under 7(2), if says that deposits are invalid, I will redeposit. Entire question, if I do not admit that I am a defaulter, my lord, application under 7(2) entails a application under section 5. And that is my application under 7(2), adjudicate my deposits.
no, but 7(2) says,
Yes.
I agree with you that Chamaria said extension of time to deposit the arrears cannot be given by the court.
Yes. It
But-
does not say that 7(2), there is no application under section 5. Nowhere it is stated. And my is my lord, simpliciter 7(2). Without
But
admitting.
7(2) says that within the time specified in 7(1), you have to come.
Yes, that is time for filing application. Therefore, section 5 applies.
And when you come within
Payment is mandatory. But the within 1 month is not
but
mandatory.
7(2) is subject to
Yes.
your depositing of the rent with the civil judge.
No, that is not there. My lord, that is application. I am not allowed to do it. That is to be determined. Amount admitted by me,
Admitted by you.
but I have not admitted anything. I am saying I am going on deposit with the rent control.
So that is, you have to suffer the consequences of that.
No, that is whether that is to be, that is a dispute within the meaning of 7(2). If it is a dispute, it is.
You are saying it's a dispute. But
Therefore,
point
it
is
is
here
to be.
not the whether it is a dispute. Point is what time,
Point is whether section 5 applies on
within which time you are supposed to come with the dispute.
30 days.
Then
my lord, whether that can be extended by section 5.
But
That
subsection
period has not been held to be mandatory.
section 2 is.
My lord, at least in this case, that date of, that is what I first, my lord, I pay the amount. I say I am a defaulter to the extent of 10 rupees, I pay this. I do not file, my lord, 7-2. 7-2 I filed after lapse of time. Whether section 5 applies. Mandatory is the payment of admitted areas. Now, my lord, your lordship,
কি বললাম? That deposit of rent was mandatory and required to be scrupulously followed by the tenant if the tenant had to avoid eviction on account of non-payment of arrears of rent. Mr. Bakchil, a senior advocate, submits that the court does not have the power to extend the time extend the time for deposit of rent by applying the provisions of section 5 of the Limitation Act, but an application for adjudication of the rent payable in case of a dispute with regard to the quantum can be filed belatedly by applying as section 40 of the West Bengal Premises Tenancy Act 1997 makes the provisions of the Limitation Act applicable in all proceedings and appeals under the 1997 Act. According to Mr. Bakchi, the tenant has continuously continuously deposited the rent and is not in arrears before the learned rent controller. Now, what did you want to seek through 7-2?
my lord, I am declared that I am not a defaulter.
And
13, your page 13.
require and ask the learned court below to adjudicate the issue of default and declare that the plaintiff defendant was
taking
not
consider and deposit before the. This is what I submitted.
Page 15 was not a defaulter. Page 15. By taking into consideration the deposits made before the learned rent controller. But after the suit and receiving summons, how can you go on depositing in the rent controller? That is contrary to the statute.
My lord, kindly section 20. There was section 20.
20 is for increase of rent.
No.
21 is deposit.
Kindly.
21 na? Deposit with the rent controller.
But there is a provision. No, yeah, it is increased. I am not.
Deposit of rent by 10, 21.
21.
All right, come back. Service upon the opposite party. opposite parties and also the learned advocate conducting the case in the, conducting the matter in the learned court below. Stay of all further proceedings in ejectment suit number 228 of 2022 till August 31, 2023. List this matter under the heading motion on August 8, no, 21st August.
আমি পলালাম রে,
এটা একটু দিয়ে দাও।
পলালাম রে যেমন দিতে।
Now, next.
Right. 29, my lord. This is my application for expediting a suit of ejectment filed before the Presidency Small Causes Court at Calcutta in the year 2015, my lord. Presently, the suit is posted for further cross-examination of PW1.
Take down.
My lord, only may I just indicate one thing? At that stage, we had filed an application under Order 6, Rule 17. Even that is pending from
So
7
who's
June.
responsible for the delay?
My lord, but still
Order 6, Rule
2000
17 after cross-examination.
after, my lord, because there was a change of, my lord, I'll tell my lord candidly, if my lord kindly goes through the plaint, my lord, it was never happily drafted, my lord. The grounds that have been,
after the stage of
my lord, I bow down, there was a change in the conducting advocate and it was brought to record. But however, my lord, the delay, even if I assume that still till 2022, my lord, there has been intermittent delay in conducting this case. My lord, for whatever reason, my lord. 2015, it was filed till 2022, 7 June, when Order 6, Rule 17 was filed. And my lord, sees for 1 year after.
How many amendments did you file throughout?
My lord, that was for Order 22. That was in connection with Order 22, Rule 3, because to bring the
Yes.
Deceased
Heirs of the deceased.
onto the record, my lord.
Take down. What did you want to bring on record?
My lord, they wanted to incorporate the ground that a reasonable requirement is also there. My lord, whatever, my lord, let it be dismissed, my lord. Because even I understand, I bow down before my lord. I bow down before my lord that it cannot be filed. My lord, ejectment on the ground of, my lord, very vaguely described as default and as well material deterioration in the subject suit property. No, my lord, this is under the West Bengal Premises Tenancy Act, my lord, not under 106 of the Transfer Property Act, my lord.
Change and alteration in the.
My lord, these were the grounds that had been vaguely described, my lord. My lord, I bow down. What has fallen from my lord that this application perhaps is not maintainable at this stage. My lord, let it be disposed and let the suit be concluded and at the earliest, my lord. That is all what I'm beseeching before my lord today.
Take down. The petitioner is the plaintiff in ejectment suit number 209 of 2015, pending before the learned Small Causes Court, 4th bench at Calcutta. The petitioner prays for expeditious disposal of the suit. The records reveal that after the cross-examination of PW1 was completed, the petitioner filed an application for amendment of the plaint under Order 6 Rule 17 of the Code of Civil Procedure. This court finds that the said application has been adjourned on several occasions and Next paragraph. Although the suit is of 2015, it appears to the court that at the stage of cross-examination, the petitioner himself had prayed for amendment of the plaint, which is yet to be decided. The court is of the view that the learned court below cannot be faulted for the delay. However, as the application is still pending disposal, let the said application under Order 6 Rule 17 of the Code of Civil Procedure be disposed of. This within a period of, when is the next date fixed?
My lord, the next date is
On its own merits.
6th of July, 2023, my lord.
Within a month from the next date fixed upon affording adequate opportunity to all the parties to contest the same.
My lord, written objection has been filed.
As the petitioner prays for after disposal of the application for amendment, comma, an application for the suit shall proceed expeditiously and all efforts shall be made to conclude the same within a period of a year from date. Within a year from date. This court has not gone into the merits of the application for amendment. The court has also not expressed any opinion on the merits of the suit. The learned court below shall proceed independently and on the merits of the state application and the suit. Direction for expeditious disposal would inure to as this direction for expeditious disposal will inure to the benefit of all the parties. The learned court service of notice upon the opposite parties prior to disposal of the divisional application is not necessary. The petitioner is directed to serve. Yes.
Much obliged, my lord. Much obliged.
Next.
My lord, I appear on behalf of the petitioner, my lord. My lord, I appear on behalf of the petitioner, my lord. My lord, this application have been filed for disposal of the injunction application, my lord. The opposite parties, they have instituted a suit for declaration and injunction.
The petitioner is you are the
I am the
is the defendant number one in
number one,
suit number 138 of 2023. What do you want? But is service upon the other defendants complete?
My lord.
Have the written objections been filed?
Yes, my lord. A written statement and written objection both have been
By
filed.
you. What about the other defendants? How many defendants are there?
My lord, 3. Other than me, there are 3 more. My lord. My lord, kindly sees page 5, my lord. Paragraph 5 of page number 4, my lord. Defendant number 2 and
Page
4, my lord. Paragraph number 5. The defendant number 2 and 3 has also filed.
All right.
written
Yes.
objection,
Yes.
my lord.
The petitioner prays for expeditious disposal of the application for temporary injunction pending before the learned civil judge, junior division, first court at Barashat. Ad interim refused.
No, my lord, it's extended till 18th of August.
The petitioner submits that
9th August.
the ad interim order of that all pleadings are complete and the defendants have filed their written statements and written objections. When is the next date fixed?
Well, it's extended till 9th of August.
What is the next date? Where is the order sheet?
Well,
Where is the order sheet? When is the next date fixed? Next paragraph, as this is an application for expeditious disposal of the application for temporary injunction. This
next
does
date
not
is
find it
9th
necessary to
9th of August for
direct issue of notice upon the opposite parties. All the parties stand to gain if a litigation is progresses, if a litigation progresses on an urgent basis. Stop.
my lord, it's 9th of August. My lord.
Thus, considering the contentions of the petitioner, the revisional application is disposed of with the direction upon the petitioner, upon the learned court below to dispose of the application for temporary injunction within
But before puja vacation.
within 3 months from the next date fixed. Full stop. It is made clear that this court has neither gone into the merits of the application for an injunction nor into the merits of the suit. The learned court shall hear out the matter upon according adequate opportunity to the respondents, to the opposite parties, to contest to all the parties, to all the parties to advance their arguments before the application is disposed of. Copy service. Yes.
My lord.
No. Next. Follow, no? For execution. কি হয়েছে? তাও কোথায় সেগুলো? ওটাকে আমি কারেকশন করলাম, ওটাতে করেছি মনে হয় না, টপ শিট করেছি, করলাম। Miss Case,
That's true.
Miss Appeal. Take down. Now,
Then it's liberty to take back the
original
certified.
the application for, the petitioner has assailed an order of rejection of an application for preemption. This is an appealable order, full stop. Petitioner is granted liberty to take back the certified copy of the order impugned, judgment and order impugned, and by furnishing a photocopy thereof. Yes. Upon furnishing a photocopy thereof. Next.
But I beg to appear for the petition. But application for recalling under section 151 was filed arising out of dropping of the mis-execution, title execution. But that was done because, my lord, no steps was taken, as my lord, first appeal was pending and order of stay was there. And thereafter, my lord, an application for recalling was filed.
What
That
was the order passed which you wanted to be recalled?
My lord, that order, my lord, against the arising out of the dropping of the
Show me the
execution.
order. Show me of the order.
14 September 2017, that I have annex page 71. And type copy is next page.
এই মুর্মু কোথায় দিলীপ? অনেকগুলো আছে, প্রত্যেককেই ফোন করতে হবে তো। আর এগুলো নিয়ে ফোন করতে বলো। তো নিচের কোটে আবার অর্ডারটা যাবে না? Yes.
At page 71,
Hmm.
order dated 14 September 2017.
Hmm.
The title, the execution case was dropped by the learned court below. And I made an application under section 151 for recalling of that order. That was rejected by the learned court below. By observing,
Of all proceeding, man.
my lord. There is an order of the stay by the learned of this honorable court in a appeal, first appeal,
In the execution case.
in the main case, in the suit. Stay of the, my lord, the judgment and degree passed by the suit, passed in a suit.
Stay of judgment and decree. So the executing courts disposed of the execution case.
My lord. And made an application 151, that was also rejected.
First and foremost, stay is not given. Usually execution will not proceed. That is the
My lord,
normal
my lord.
injunction that is given.
That is given.
Where is the order of this court? Have you annexed?
Yes, yes.
Show me. Your sir will
Page
come back. What-
44,
Page?
44, 44.
ওই advocate and record দিলে একটু বলে দে একটা mistaken date ছিল। হ্যাঁ হ্যাঁ।
And LCR also
কারণ
called for.
ওটা নিয়ে গিয়ে যদি ট্রায়াল কোর্টে দিয়ে দেয় তো অসুবিধা হবে ওদের। ডেটটা ভুল। Where is the order?
Page 44, 44.
No stay. High Court
No,
has
there is no stay.
directed
In the first appeal, my lord,
status quo will be maintained. And
first
how
appeal
Shiva Puja will be going on. When did you put the decree into execution?
in 2010, the order when the degree was passed,
Before the appeal court's order.
before the appeal court's order. June 29 June 2010, and the my lord execution case was filed.
Take down.
20th April 2010.
What is the reason for the,
My lord, there is no scope to recalling the application 151. You have to approach
Restoration of
Restoration.
the, like, why a had been dropped,
Dropped.
but dropped is not dismissed for default.
Default, that is my assumption, sir. That is not for
Why
default.
drop? Service or service upon the opposite party. Where is, oh, so many opposite parties are there upon the opposite parties? There's also the learned advocates appearing on behalf of the opposite parties in the learned court below. Let this matter appear on. How long? You will take a long time.
No, it is within Howrah, my lord. It will take 1 week.
How many parties are there?
My lord, that can be possible. Within
Possible?
same area they are living.
Because
Salke
post-
Howrah,
with-
that is.
All right. 24th July,
24th June.
under the heading urgent motion. The petitioner is aggrieved by the order dated December 21, 2022, passed by the learned civil judge, Senior Division First Court at Howrah, in title execution case number 2 of 2010, which arising out of title suit number 55 of 2005. By the order impugned, the learned court below refused to recall the order dated
14 September 2017.
17
14 September 2017.
September 14, 2017, by which the execution proceeding had the title execution case had this proceeding now. The title execution case had been dropped by the learned executing court. Where is the order? Just show me that order, earlier order.
Page 44 of the court, of this court, appeal court.
No, no, no.
Original suit.
Execution court first matter, first order.
First order, my lord.
Drop.
Drop
that order.
page 71. At the bottom.
Dropped of all proceedings.
Grateful.
Number 33, I am for the petitioner, my lord. This is for expeditious hearing of my matrimonial suit, my lord. My lord, marriage is of 2013. My lord, the wife, my lord, left the matrimonial home in 2019. My lord, now I was compelled to file a suit, my lord, in 2022 on the ground of desertion.
What about payment of
My lord, that has not yet been, my lord, she has not yet filed, my lord, any application for it. Maintenance or, my lord, alimony.
Take down. The petitioner is the husband in matrimonial suit number 358 of 2022, pending before the learned additional district judge, fast track court at Kollani, Nodia. It appears that only on January 10, 2023, the opposite party wife appeared in the suit. By filing Wakalat Nama
13th, 4th,
and
2000.
on January 10, 2023, and prayed for time to file the written statement. আবার put up কি আছে?
Yes, my lord.
What is this for?
Malad, this was for Malad early hearing of the Malad, since Malad the WS was not Malad filed Malad. That is why Malad the put up was given.
You are making, you put a petition has not been served then? For SR?
No, this was for Malad 16/12/2022. And Malad, this order kindly come to see order dated 6. Oh, this was the type copy of that.
So after April,
Malad, this was the type copy, Malad.
after April 4/13, what happened?
Malad, thereafter Malad, she didn't Malad file the detail statement.
When is the next date?
Malad, next date is in month of July.
At this stage, what expeditious disposal are you
Malad,
guys?
since
You have to
Malad-
file a WH.
Malad, since Malad, this petitioner is suffering since Malad 2019.
Huh?
Yes, 2019 Malad, she left Malad her matrimonial
So-
house Malad. Marriage is of 2013. Malad, initially I Malad filed a
Take down.
application for restitution of conjugal rights,
Your
but she didn't
application,
return.
Is at its nascent stage. The suit is at its nascent stage. And the opposite party has not yet filed the written statement. Neither has the opposite party filed any application for maintenance pendentility. At this stage, it would not be proper for the court to direct expeditious disposal of the suit. However, the learned court is requested to ensure that parties are vigilant and diligent in pursuing the suit.
Malad, without granting any unnecessary
Huh?
charges.
First you pay, let the money be determined.
Malad, I take back my wife, Malad. Send this matter to the mediation, Malad. But later come back, Malad.
You go and offer her
Malad.
to come back. Why has she left you? You must have done something after 5
Malad, every
years.
time, Malad, husband does, Malad,
Why will she leave you after 5 years?
2 hands, Malad.
That the court will see. Yes,
Well.
next.
Lord, I am for the petition. But one of the defendant is the petitioner before your lordship in a suit for partition. Lord, in partition suit, I filed an application for dismissal of the suit on the 2 grounds. First, all the suit property, all the joint property was not brought on record, and the all co-sharers were not brought on record.
Yes.
But this application was rejected by the learned trial court only on the ground this point shall be decided after recording the evidence.
Yes.
Lord, my client filed a civil revisional application under section 115 capital A state amendment before the learned district judge, and the learned district judge also approved the order of the learned trial court. Now, Lord, I am before your lordship. Lord, what I pray, Lord, Lord, let there be a direction to frame the preliminary issue on that point,
Which point?
whether the all suit property was brought on record or not. If I succeed, matter will be ends there. If I do not succeed there, then the next date, Lord, the partition.
The issue on a point of fact.
Lord, the point of fact, Lord, the kindly decide, kindly direct, otherwise, Lord, this suit shall be, Lord, the continue for years together.
It is direct expeditious disposal, or whether all suit properties were brought in is a question of evidence. How can it be decided as a preliminary issue? First, you have to show that these are the plots. They have to say, no, these are not the property. Only then.
Yes, Lord, the evidence has to be recorded there.
Yes, so
Lord,
then how can that be as a
Lord, that
preliminary?
is why, Lord, what I pray before your lordship, let there be a direction to decide
Not
this issue.
expeditious disposal. That I can give. Issues have been framed.
No, my lord.
What is the stage of the suit?
Lord, after rejection of the order of injunction, after granting the order of injunction.
An injunction application at interim stage or disposal?
Over.
All right, now issues will be framed.
Yes, my lord, the issue will be framed at the, my lord, the
All the issues, not
all
only
the issues.
Yes, take down. The petitioner is aggrieved by the orders passed by the learned civil judge. No, learned district judge, bracketing in charge, Nodia, in Civil Revision number 1 of 2023, as also the order dated November 29, 2022, passed by the learned civil judge, Senior Division, 3rd Court, Krishnagor, Nodia, entitled suit number 92 of 2022. The learned trial judge
Title suit number 96, not 92.
96, sorry, title suit number 96 of 2022. Rejected the application filed by the petitioner questioning the maintainability of the suit. According to the learned trial judge,
Last page, my lord.
the application for maintainability was malafide and motivated. The contention of the plaintiff, of the defendant, that of the petitioner, of the petitioner, that all the common properties were not brought into the hodgepodge of the partition suit, within the purview of the partition suit, was not accepted by the learned trial judge on the ground that the suit was in respect of an undivided HON'BLE property with regard to common interest and common possession, and the plots owned by third parties were not required to be incorporated in the suit, in the plaint, or were not required to be incorporated as subject matters of the suit. According to the learned trial judge, the issue as to whether the suit was maintainable in its present form or bad for any defect, including the defector of misjoinder and or non-joinder of parties, any defect on account of misjoinder and non-joinder of parties, or on any other account, would be decided on evidence at the stage of trial. Stop. Such order was challenged by way of a revision, and the learned district judge upheld the order of the learned trial judge, inter alia holding that whether the suit was backed for defect, any defect including the defect of seeking partial protection, partial partition, was a matter of trial. This court does not find any illegality or material irregularity in the orders impugned before the court, whether the property is belonging to third parties or whether third parties should be brought into within the purview of the suit, or the fact whether the parties to the suit had other common interest in immovable properties beyond which were not brought into the purview of the partition suit are matters to be decided on evidence in trial. This revisional application is thus dismissed. However, this order shall not preclude the learned court below from proceeding expeditiously by framing the issues, including the issue of maintainability, and proceed with the trial of the suit in accordance with law. Yes, no. This court has not expressed any opinion on the merits of the suit. Yes. Where is it? Next.
Well, before my learned senior friend begins, Mr. Shashwat Nayak is appearing for respondent 1 and 2 in this matter. But he fell ill in the morning at around 12ish. 12:30 he left. He was advised to go back home. I had only humble prayer.
Be able to come.
But it kindly gives a week's time, my lord.
Is it, when is the next date fixed?
Well, no date has yet been fixed. The court is vacant, but DRT 1 is sitting on every Friday and adjourning the matter day after day.
You want an expeditious disposal?
No, I have challenged the order passed by appellate tribunal,
Appellate tribunal.
wherein the matter has been remanded to DRT 3. And we are on the plea that his own reasoning was not there. But it appears from the order passed by DRT 3 that he gave details reasoning. And Millard, on the plea, he has just
All right, so can he come on Thursday?
But it keeps it on Friday then.
Friday?
Friday.
yes.
All
Then
right,
in the meantime, Millard, they should not proceed there.
that is understood if
Yes.
he's asked for time.
Or status quo is on the day.
All right, now, on the prayer of the learned advocate for the opposite party, the revisional hearing of the revisional application is adjourned. Let it appear on next Tuesday,
The next Tuesday will be, my lord.
13th, no,
But any day other than 19th, my lord, is what I was told.
20th.
My lord, 20th.
20th.
20th, my lord.
Yes.
It is expected that the party shall pray for an adjournment before the learned tribunal on the next date fixed.
Well,
The
Parties are at liberty to pray for an adjournment.
My lord, grateful. ma'am.
the
Next. কেউ নেই তো দেখি কি কোর্টে গেছে নিউ ফাইলিং
Like in fact, 36, it will be called on after completion of the supplementary list, today's list. However, it is shoot for,
36 of the supplementary list.
yes, madam.
So what are you saying?
It is a case for a direction for expeditious disposal of title suit, which was filed in the 2012. During the pendency of the suit, my lord,
What is the stage of the suit?
actually, my lord, should order 39 rule 1 issue. It has been because two suit was thereafter injunction order was passed, status quo, therefore suit was dismissed. In the meantime, defendant plaintiff was died interested and said substitution recusal allowed last test. But it is continuing from 2012, my lord.
So setting aside abatement order was passed.
All are complete.
Take down.
If you are saying direction for short, if it is possible, my lord, to dispose the suit as early as possible.
Abate করে বসেছিল, you didn't take any
And
steps.
that suit was allowed, but that happened was allowed. My lord, this is the page full hearings. I've already stated my
When is the next date fixed? Written
22nd
objection has not been filed to the
22nd December 2021, my lord. That application was allowed. Now, my lord, last my lord,
What
thereafter,
is miss case 15?
that was
What is it?
application for my lord, substitution or setting aside.
Has been allowed?
Allowed.
Because in the order sheet, it's not
My lord,
reflected.
but my lord, you lord, share the sheet order,
Where is that?
accepted the. You also can see the order 52, dated 22nd, 20 February. Petitioner's application for limitation with Section 5 with amendment application allow, my lord.
Order number 52.
I have the order number 52, 20th February, my lord.
I don't have that order.
My lord, page, my lord, that is the order sheet I have already annexed that after
Yes,
15th
yes.
October 20.
52.
52, order number 52, my lord. 20th February, my lord.
Then why?
Thereafter, suit was dismissed. That means when dismissed after registration application was filed with section 5. That was also allowed, my lord. 20th February, my lord, 2021 order. First order sheet, my lord.
Now you show me from the records.
This is the plain, my lord, I have annexed
What
P1,
is miss case 17?
miss case 17, my lord. Now that application has not been annexed.
This is miss case 15, but there is another miss case. What is that?
Resolution, but because all are resolution of the court, my lord, civil junior divisions court. Bar. His lordship rightly missed case 17, my lord. That
Order 22 rule 9 application.
is. That application for restoration, order 9 rule 4. I wish section
Oh, order 22 rule 9
order to
for setting aside abatement.
Yes, my lord.
কি হচ্ছে আমি তো বুঝতেই পারছি না। There are two miss cases, one of 15 of 2016,
And another, my lord,
17 of 2021.
and
What
another.
is the application for 17 of 2021?
Probably, my lord, 15 is, my lord, restoration after is section 5. That was allowed. Probably, my lord, that application, there is no probably, my lord, substitution application, it will be, if it is. Order 9 rule 9.
Take down. The petitioner prays for this early disposal of, unless the miss case is allowed, how can I direct
My
the,
lord, miscase, my lord, you are CBD, any miscase, that will be disposed of after thereafter. If it
so
is.
suppose your miss case is rejected?
No, no.
If it is order 22 rule 9 and
No,
it is rejected, then suit abates.
No, should have it, but in this case, my lord, plaintiff is the petitioner before your lordship.
So if it is order 22 rule
Yes,
9, it is an application for setting aside abatement,
Yes, ma'am.
right?
Yes.
Now, if I say that the miss case and then suit, doesn't it mean that I have directed the miss case be allowed
No, no, allow, my lord,
or
dispose.
setting aside amendment? কি বললাম? Title suit number 239 of 2012 pending before the learned civil judge senior division Kakdeep at district 24 Pargana South. Records reveal that miss case number 17 of 2021 is pending since long. And dates have been fixed for SR of the miss case. In relation to the miss case, the learned court below is directed to dispose of the miss case upon affording an opportunity to all the parties to contest the same. When is the next date fixed?
No, my lord, no date.
Resolution shall be made within, what is the next date?
My next date has already been, my lord.
2 months from the next date fixed. Thereafter, if the miscase is allowed, the suit shall proceed expeditiously. This court has not gone into the merits of the allegations, either in the miscase or in the merits of the case of the petitioner, either in the miscase or in the suit. The learned court shall proceed independently and on the basis of records and the law. The petitioner shall serve a copy. তার আগে লিখো as an innocuous affair has been made, sir, prior service is not required. The learned court below shall proceed strictly in accordance with law and on the basis of records. Yes. Service হবে revisional application along with a server copy of this order. Yes.
অর্ডারটা বার করে দাও। Sure.
Page 49.
I am appealing for the petitioner. The petitioner is the plaintiff husband in the matrimonial suit, my lord, for divorce, my lord, on the ground of cruelty, in the sense, my lord, the wife was suffering from an syndrome disease. It is called scleroderma, which he was not aware of. Plus, my lord, within 2 years of marriage, they were living separately.
Is there any order for interim in maintenance pending?
Under Domestic Violence Act, it is being paid, but under the Special Marriage Act, the application was dismissed. They have filed an application for recall that is pending. Now, one of the difficulty is from 2015, I am in the box. 2015, we are 2023. Cross-examination has not been completed. Your lordship will come to page 48. There is a previous order by this court.
Why was the application for refused?
Because she has a income, higher independent income.
And how much has been directed to be paid in the domestic violence case?
কত?
30,000.
30,000 and 10,000 is the residential order. Litigation cost.
30,000 as litigation cost and 10,000 per month.
As residential. Well, we are now concerned with, my lord, the fate of the progress of the suit. My lord, page 48, your lordship will come 13 September 2019. This order was disposed of, directing, my lord, this suit to be disposed of with all connected applications within 1 year from the date of the communication of the order.
Application for maintenance is miscase 58 of February 15.
Yes.
All right, take down.
But only one thing, my lord, I would just want to show your lordship certain things, my lord. My lord, 1 year from this date, I take it, my lord, that COVID intervened in March 2020. Your lordship will kindly note one thing. From 1st March 2022, everything became normal in terms of the Supreme Court order, limitation revived and everything. So from 1st March 2022 till 31st December 2022, only one date was fixed. That was in 10th of August 2022. Then again, after 10th of August, the next date was 2nd February, 3rd February, 4th February. Well, thereafter, 3rd April, one more date, their adjournment was taken by them. Series of adjournments, but kindly, this is the predicament, but somehow, and I do not know what will happen. Your lordship will also appreciate this fact. For more than 10 years, they have been living separately with no chance of reconciliation.
Go to mediation.
I am told, well, it has failed several times. But ultimately, where would it lead to? They are all saying it is not even nobody's case.
If mediation has failed, what can be done?
There is no restitution application.
There is no restitution application. Not even, my lord, in the written.
Is she working?
Yes.
Where is she working?
I think it's in a contractual post in the Jadavpur University.
Okay.
Assistant professor.
The petitioner is
Some
the
amount of
husband-
anxiety, my lord, if your lordship may kindly express.
The
My lord, this is the
husband in
second time.
matrimonial suit number 123 of 2013 pending before the learned additional district judge 13 court at Alipur district 24 Parganas South.
But kindly say in a day-to-day hearing.
By the
My-
order impugned, no, the petitioner is aggrieved by the inordinate delay in conclusion of the matrimonial case. It is a specific contention of the petitioner that the money which has been directed by the learned court under the Domestic Violence Act is being paid regularly. It is further submitted that the application for maintenance pendentility has been rejected by the learned court below, and an application for recalling of the same is pending. Having gone through the records, it appears that the title suit, the progress of the title suit, a matrimonial suit had suffered during the pandemic, and long dates have been fixed by the learned court below. It also appears that
Cross-examination is continuing from 2015.
cross-examination of the PW1 is continuing from 2015. Under such circumstances, the anxiety of the petitioner is not unjustified. An order of expeditious disposal of a litigation inures to the benefit of all the parties. Thus, this court is of the view that prior notice need not be served upon the opposite party wife before disposal of this revisional for disposal of the revisional application. Accordingly, the revisional application is disposed of with
The
a
lordship will
direction.
also note the previous order of this court.
With the
Nothing has
no,
taken
It also appears from the records that an earlier order was passed by this court directing, where is that?
My lord, page 48 at 49. Progress did not suffer during lockdown, my lord. I am saying that if I give that benefit to the court, even then, after 2022 March, what has happened?
Now, the attention of this court has been drawn to the order of a learned coordinate bench dated September 13, 2019, by which the learned court below was directed to dispose of the matrimonial suit within a year from date of communication of the order. It appears to the court that the said suit has not yet been disposed of. Even the application for recalling is still pending.
Cross-examination is still continuing.
The cross-examination of PW1 has also not concluded. Under such circumstances, this court directs the learned court below to dispose of the recalling application within a period of 1 month from the next date fixed, and thereafter.
That
proceed
will be a
with the-
great prejudice, my lord. Let it continue side by side. My cross-examination has
No,
to be.
but the only reason is, Mr. Sen, if.
Recalling is not maintainable. It's a question of appeal.
No, 1 minute. Whatever it is, dispose of the matrimonial suit number 123 of 2019, along with any pending application within a period of 6 months from the next date fixed.
No, it is
This court has
2013.
2013, sorry. This court has neither gone into the merits of the suit nor into the merits of the recalling application. The learned court below shall proceed in accordance. with
Only
law.
one line, my lord. Let the learned court below adhere to this schedule. But every time I cannot come by way of a 227, my lord.
It
It's
is
the
made
second
clear
time
that
we are
the
coming.
learned court below shall be at liberty to fix the dates and intimate the parties so that parties are restrained from, parties do not pray for unnecessary adjournments on the dates or the schedule to be fixed by the learned court below.
And this expectation that this time schedule may be adhered to. I'm sorry, my lord, but
The matrimonial, as the matrimonial suit is pending since 2016, the learned court is requested to adhere to the schedule.
I'm obliged. My lord. 2013.
13, sorry.
Obliged.
Yes.
I appear for the petitioner in this matter. This is arising out of a reference case before the land acquisition judge at First Court Alipur, 24 Parganas. I am the referring claimant. Award was passed in my favor. high adequacy of compensation was referred by me through collector. At the time when the adjudication was there, order 1 rule 10 application was made by someone claiming to be that he is a co-sharer, and the court allowed him. This without regarding the judgments in Galore has been cited to him. The referring court cannot directly, my lord, in a reference under section 18 can entertain any application filed by any third party. They cannot entertain. He is to come to the collector, and collector also, my lord, has no power to extend the time limit under the provisions of Limitation Act. How could he do this, my lord? So many judgments were considered, my lord, and ultimately a Punjab judgment he has considered old 84. Up to 2013, the Supreme Court, 2013 Supreme Court I have got has said that no, referring court cannot entertain such an application.
Who has made the reference?
One of the claiming to be a co-sharer. Claiming to be a co-sharer.
No, but this is not under 227. How can I be, this is an order of whom?
Order of the learned district judge.
No.
Yes,
where?
that is there.
Show me.
Special land acquisition judge, Alipur.
Where is the order?
That order is at very first annexure.
Oh, that's why.
Initially, one team went to the collector rejected it. Another person went to the court, directly court has entertained.
He has been added as a party.
How could he? He has been added as a party in my proceeding, in a reference case, without being referred by the collector. In a land acquisition reference, section 18, it provides for the provisions under which reference can be made, and time limit has been specified. The land acquisition compensation adequacy is the issue, and he has converted it to a partition suit. Apportionment of compensation. How could he do this?
So, but what is the remedy of a person who?
File a suit. File a suit. There is nothing, no remedy. It does not lie at all. If you have a claim, write in the property, file a suit against me. That I have taken compensation, he is entitled to the share of it. Award was passed in my favor. I have filed reference matter on the ground of adequacy of compensation. If someone is claiming to be having interest in the property, he should have preferred.
But section 18 says you have the act.
Yes.
About who is entitled to compensation.
That is also a part of reference. Section
No.
18 also, my lord. These issues have to be decided.
এই একটা ল্যান্ড রিফর্মস অ্যাক্ট আনাও না
বইটা কোথায়? হলদে বইটা? হলদে বইটা কই?
ল্যান্ড অ্যাকুইজিশন অ্যাক্ট
Yes, I have land acquisition. Yes, well, I am showing it to you.
হচ্ছে সেকশন 8 এর তোমরা আনছো না।
Collector is to make a reference. Slide, kindly come to my lord, section 18. Here is the section 18.
দেখি see the persons to whom it is payable.
Yes, person to
point
whom
is
is
there.
that is to be apportioned by the collector. The dispute is to be raised before the collector. Collector is to refer it to the court.
So he went directly and got his.
Directly went there.
Serve and come back.
জি বইগুলো রাখ
Service upon the opposite party. Opposite parties. State of West Bengal, serve them
State as also the private respondent.
the there shall be stay of operation of the order dated April 24, 2023, passed by the learned Judge Special Court, LA Court, Special LA Court, First Court at Alipur. Judge, Special LA Court, First Court at Alipur, in area 316 of 2004, up to 31st August 2023. Let this matter appear for hearing on 23rd August, as a motion on 23rd August.
1st August, she stayed it till
31st,
31st August, yes.
affidavit of
And
service.
23rd August, the matter will appear. চল নিয়ে চল। আর বইটা দিয়ে দিন
এই বইটা একটু দিয়ে দাও।
Great. My lord, will take up this matter. It might take some time, my lord. Item number 39.
স্টেটা করেছে
Yes.
না স্টেটা হয়েছে তো
My lord, I beg to appear on behalf of the petitioner. My lord, the petitioner is claiming right of residence on account of 3 reasons. First,
Which place?
matrimonial. As
What is
daughter,
the application which has been rejected?
yes, my lord, I have filed an application, title suit I have filed against that order 39 rule 1-2. I have filed, that was rejected. The appellate court prima facie found that I am entitled to stay there. So ordered that interim order passed that I may stay there up to the final disposal. My lord, what happened is during that period, I was ousted from my place. How? I go to school for teaching. When I return back, my daughter is also there. I go to teaching, and when I come back, then I saw that the lock and key has changed, and this was the situation. So I filed an application under 151 for restoration of my possession, and so that I might be the rule of law may stay. My lord, what happened that the court below finally disposed of the miscellaneous appeal in a hurried manner and said that no, you do not have any right, because in a similar there was another title suit in where for same buildings, different property, I was evicted. So the court below in the interim stage has decided that no, you are not entitled to stay there because in that suit the parties were the same. So you are not entitled, without going into the matter that prima facie case of my living is there. Or secondly, balance of convenience, at least the suit, till the disposal of the suit, I should have this possession, because that was in respect of a different property. Same property, but different flats. They say that the court below has said that no, you have suppressed that you have been evicted and decided in the primary stage that no, you are not suitable for staying here because you have lost in that case. How can it be possible, my lord? My lord, I have judgments of the Supreme Court also whereby it is stated that the daughter-in-law has right to of residence, and that judgment is
Yes, but that is under Domestic Violence Act, isn't it?
my lord, respectfully, I submit, my lord, that what has been stated is that section 17(1) is an independent right. Even under Domestic Violence Act, even if there is no domestic violence, I have a right to stay. My lord, I will place that judgment before your lordship.
Which is the order you are impugning here?
My order is that finally disposing of that my miscellaneous appeal, and
saying that my section 151 application has become OTOs. My lord, I have a case law of this honorable court division bench
One
that
minute.
whenever
You are the wife.
I am a wife of the pro forma opposite party 2, but I am daughter-in-law of opposite party 1.
Who is the plaintiff? You.
Me.
You filed a suit for?
For declaration that I have a right in that property to stay. And along that, I am also claiming tenancy because they are taking rent from me. And in spite of all this, I have supplied the prima facie proof that I am living in that house.
No, but the point is in the eviction suit, bailiff had already handed over possession.
No, that is what I am saying, my lord. That is in respect of the first floor, 3 rooms in the first floor. Now I am possessing 2 rooms in the ground floor, and that is a separate. That is why I have described 3 schedules of property: schedule A, B, and C. The 3 schedules are: A is the whole house, schedule B is the 3 rooms in the first floor, schedule C is 2 floor in the ground floor and 1 kitchen. That is what I am on. My lord, that should not be pre-decided at this stage of the suit. That eviction has already been done. I have filed an appeal that is pending. That is different issue. But at least for my right of residence, mere right of residence, because I do not have any other alternative. From the date of marriage, I am staying in that house. Now, suddenly, if somebody evicts me, I was also ready to pay the rent. I have paid 2,000 rupees rent. But I cannot be evicted with my daughter. My husband is living in Jharkhand due to job-related work.
So refusal to grant an injunction, that was the subject matter of challenge before the appeal court.
Yes, my lord.
So an appeal court dismissed your application.
My lord, on
and refused to interfere with the trial judge's order.
My lord, on 2 grounds, I have filed this revisional application. First one is that being a daughter-in-law, I have a right of residence in that house, at least temporary. Secondly, prima facie, I have proved that I'm staying there by filing
But
documents.
the courts have found that your prima facie not in possession.
My lord, no.
Yes.
My lord, kindly comes to the order. Page 119 and 20.
I'm directing the application for temporary injunction to be disposed of expeditiously. When is the next date fixed?
My lord, I am asked from the.
You have been ousted long back.
My lord, kindly comes to.
There is a question of restoration of possession. Your application for ad interim injunction was prayer for ad interim injunction was refused. You preferred the appeal?
No, my lord, in the appellate court, it was allowed. My lord, kindly comes to page 119 and 20.
119.
Initially, I was allowed to stay there.
Yes, then final disposal.
My lord, when the order was.
Wait 1
there,
minute, let me check.
I was initially given that order ad interim protection. In spite of that order, I have been ousted. And I have a judgment of this Honorable Court Division Bench that in such cases, Section 151 is squarely applicable and I should be restored my position. If they have eyesight.
That was an interim protection.
That was
given
interim
to
protection,
you.
my lord. But I am also against that final order also that I have.
Interim orders, we are not we cannot alter that when the final hearing happens.
My lord, when I have a right to stay in that house, I have proven.
You have a right, but that is under another law. This is a suit for
My lord, that is what I
declaration.
am. That is why I am citing this case law before your
Court
lordship.
has found that you are not in possession. How can that factual aspect be changed by the revisional court now? Let your temporary injunction application be heard
My
of.
lord, I am not in position because I was ousted during the pendency of that interim order.
Where is that?
Then my lord, the interim order was passed saying that
court has not found anything on that.
my lord kindly comes to the documents I have submitted that my residence in that house.
Court found that you are not in possession, that the interim order was filed.
And whether the balance of convenience and inconvenience should be considered. I am there with my daughter in the ground floor and I am being ousted in spite of an order and I have a right to stay there, my lord. I have a right to stay there and that is an independent right, that what I am on. My lord, this judgment is there.
No, that restoration position is all right. That can be given. But here,
My lord, that is what I'm on. And secondly, your lordship might direct that the trial court to dispose of the interim application, but my position must be restored somehow because I'm ousted. I have to stay in a relative's place with my daughter.
ছোট বেয়ার এক লাগবে, এত বড় বড় বই হ্যান্ডেল করা যায় নাকি? এগুলো থাক, বেয়ার একটা না। থাক, এগুলো থাক, কিন্তু বেয়ার একটা না, লেটেস্ট বলে বেয়ার একটা না।
112.13 I have given proof that my daughter is staying there, that address is given in the school certificate, and then page on
এত পুরনো বই কেন দেয় এরা?
I've given my Aadhaar card Xerox copy also, that I am a resident there. In spite of that, it's in a prima facie stage, my lord. The court cannot decide that, no, because in that case you have lost, you will go away. That cannot be. I'm on the ground floor. I'm not in the same property. And that matter has been pleaded before the court below. It is not that it has not pleaded before the court below. I've given my address proof. I've stated that my relation proof, and I'm claiming as a daughter-in-law. And that too in a different property, not that tree. I'm not wanting in that address, that description. In the ground floor, I am occupying. The court bill has not gone into the
Court has
question
gone
whether
in-
I am in the ground floor or not.
Yes, that the interim order was passed upon being misled by the material
About what? That
suppression.
I have
Take down.
eviction suit has been filed against me, and that too for a different property.
All of these facts were suppressed by you and which led the court to.
My lord, but independently, I have a right to residence in the ground
That
floor.
you have, but under a different provision of law.
My lord, that is
Under
what
the
I am.
Hindu law or Hindu Marriage Act, there is no provision for residence for you. Yes, you have a right to
My lord,
claim
kindly
maintenance
consider this
and amount of rent and the rent that may be
as a
payable by
tenant
you
also.
or your maintenance that can be
But
counted.
kindly restore my possession, my lord.
No, the court found you were never in possession. Take down.
My lord, kindly, I have a judgment over my independent right. Fine, my lord. Relevant paragraphs are 24.
It is in Domestic Violence Act. That is agreed. I
My
agree
lord,
with
it is stated that independent of any domestic violence, I have a right as a resident. That is clearly stated.
24.
My lord, kindly comes to paragraph 25. 25, 30 and 37 paragraphs.
All right.
That is an independent right. That is what I am on.
Paragraph?
Paragraphs 25 is important. Paragraph 30 is important and paragraph 37 is important. Paragraph 25 is that page is 2346.
25.
25, 30,
Yes,
37.
Take down. The revisional application is directed against an order dated April 13, 2023, passed by the learned additional district judge, fast track, 4th court at Alipur, district 24 Parganas South, in miscellaneous appeal number 303 of 2019, arising out of order dated July 19, 2019, passed by the learned civil judge, senior division, 5th court at Alipur, title suit number 913 of 2019. The petitioner claim is the wife of whom?
The son of the opposite party number 1. Daughter-in-law of opposite party.
Daughter-in-law of the opposite party number 1.
Yes, ma'am.
And has filed a suit for that is the opposite party number 3, pro forma opposite party number 3, Uttam Kumar Dotto.
Yes, ma'am.
The petitioner filed title suit number 186.
No, this is 913 of 2019.
913 of 2019.
Yes, ma'am.
Where is that? Plaint, you have your next?
Yes, I have annexed. My lord, page 60.
Before the learned civil judge, senior division, 5th court at Alipur, for declaration and permanent injunction. The said suit was filed as the in-laws, father-in-law was allegedly trying to oust the petitioner from the property in question and develop the same. The husband of the petitioner was living outside Kolkata. The petitioner allegedly suffered a lot of torture at the hands of the in-laws. Prayer was made for a declaration that the petitioner was the daughter-in-law of the defendant number 1 and defendant number 2 and a lawful tenant. prayer was further made for restraining the defendants in the suit from ousting the petitioner or disturbing the free ingress and egress of the petitioner in the Schedule B property. Schedule B property in this, the Schedule B
My
property.
lord, it is described, my lord, here. My lord, page.
Are two rooms in the western side of the ground floor
Yes, my lord.
of premises number D/9, Rajdanga, Novopolli, East, Calcutta Township, page 65.
My lord.
Where is the trial court's order?
My lord, trial courts or which interim, ad interim,
Refusal.
page 119 and 120.
Hundred and 20 is trial court or
Not trial court, sorry, my lord.
trial court?
I tender my apologies.
The petition, the ad interim prayer for injunction
Page 93.
was refused by the learned trial judge. Inter alia on the ground that the relief of the petitioner seeking protection of her possession would be covered by the Domestic Violence Act. The court did not find any prima facie case in favor of the plaintiff and refused to pass an ad interim order. Aggrieved, the petitioner filed misappeal number 303 of 2019 before the learned district judge at Alipur. Initially, an order of protection ad interim protection was given to initially the petitioner's possession was protected by an ad interim order. However, the learned lower appellate court, upon finding that the petitioner had obtained the ad interim order on the basis of suppression of material facts, refused to continue the order passed in protection of restraining the defendants from dispossessing the petitioner and dispose of the appeal.
No, that is in relation to a different property. That is first floor.
The learned court below, the learned lower appellate court found that from the pleadings made under Order 39, Rule 4 of the Code of Civil Procedure filed by the defendants, and that the petitioner was ousted from the property at the instance of the in-laws who had filed an ejectment suit and had obtained possession in an execution proceeding after the suit was decreed. Such fact was suppressed by the petitioner in the suit. Moreover, the learned court found that
Well, learned court never dealt with that question, that first floor and ground floor. Never dealt with that question even. Presume that I am occupying the first floor, but I'm not. I'm on the ground floor.
from the records transmitted from the court of the trial judge that that the petitioner was evicted from the first floor of the suit property. The possession was taken over by the father-in-law who oblique plaintiff. The title suit number 913 of 2019 was subsequently filed for on the ground. Now, with the case made out that the petitioner was in possession of the ground floor and the defendants were trying to evict the petitioner. Upon finding that all these facts with regard to the earlier suit, consequences of eviction thereof and taking over possession of the first floor was suppressed in the second suit. Those facts were brought on record by the defendants by an application under Order 39, Rule 4 of the Code of Civil Procedure. The court found that the petitioner had resorted to clever drafting to create an illusion with regard to the cause of action. The case of the petitioner was found to be weak and the order of the ad interim order of protection which was given to the petitioner was recalled. Rather, the learned court below came to the finding that the order of the learned trial judge, who did not find any prima facie case on appreciation of the records to give an ad interim order of injunction, should be upheld. Accordingly, misappeal number 303 of 2019 was dismissed. When the learned court, both the learned courts below, upon a finding of fact, have come to the conclusion that the petitioner did not have a prima facie case to seek any protection in respect of the property in question, and especially when the matters with the facts with regard to ousting of the petitioner from the property in question, this in accordance with law, in a title execution case pursuant to an eviction decree, are matters of record. This court does not find any reason to interfere with the fact finding.
My lord, in respect of the ground floor, my lord,
The,
I am having, my lord, kindly recalls.
the learned court below, the learned trial judge is directed to dispose of the application for temporary injunction within 3 months from date of communication of this order and pass necessary orders as the court may deem fit and proper. The petitioner's right to claim for residence in the alleged matrimonial home under the Domestic Violence Act remains open. The decision of the apex court in the matter of A versus A reported in A comes to the aid of the petitioner to the extent that the petitioner has a right to proceed before the appropriate forum seeking an accommodation in the matrimonial house, which shall, if applied for, shall be dealt with in accordance with law and independently. Full stop. These proceedings should not be, this order shall not prejudice any relief that may be claimed by the petitioner under the Domestic Violence Act. Yes, now.